So I have recycled a previous document that we used at another class, made it for this class, and there it is. It's a study schedule. This is not hard and fast. This is not like absolute every day is exactly what we're going to cover, but it'll just kind of give you a guideline. And there we go. Maybe that's a little easier to read. So hopefully it'll clear up. If not, I'll keep working on it. But I'm going to post it for you. I'll send it out, but you can see day 1, 2 there on the left corresponds to our dates, corresponds to the section in the syllabus, which also, of course, corresponds to the book chapters and the topics. You can see on first day, we covered the introduction, the process, the basic concepts, and the license law and rules, just the intro part of that, sort of that syllabus section 21, first half. Yeah, this isn't clearing up, but I'll get it squared away before I send it to you. And we are currently on day 3. We're gonna, I need to adjust these a little bit because since we put that license law and commission rules content in the mix, it put our schedule off a little bit in a good way. I'm glad that we put that in. Go. So I just need to do a few more tweaks, but I'll get you that, and then you can kind of see what's going on. Somewhere around here, I think right after we cover real estate financing is where the midterm is going to land. That's when we'll give you the midterm. And what is the midterm? It's all it is I email you a PDF. Camera man. Okay, that one. And I'll send you that and you can print it off, take the test on your own, check your own answers, because I'll give you the answer key as well. It would be in your best interest to take the whole thing before you check the answers. Don't do one by one. That's really not going to help you as much. And then you'll grade it. I'll tell you how to grade it. And that doesn't count toward anything. It just gives you an idea where things stand. It'll be your first official longer time effort at answering questions. Along the way, we'll give you some sample questions, but that'll be sort of a chance for you to just go at it for a whole hour or more, probably more than that, and just see what it's like, because that's a whole different element to this thing. Learning the content is one thing, but being tested on the content is a whole other animal. There have been people that mastered the content, but the test just freaked them out. So it's preparing with the knowledge, but it's also preparing with the technique and strategy. And we're going to work on all of that. But the midterm will be sort of your first real world immersion into that idea. Also around the midterm time, I'll go ahead and release the 5 practice exams for you. And from that point toward the end, from the middle to the end of the course, you should lead with the practice exams, meaning that should be your first effort when you study. Always work on taking tests, test questions, and getting in the swing of that, right? Anybody ever run anything longer than like away from your kid or dog, like miles, 3 miles, 6 miles? Did you prepare for that 5K, 3.1 mile race by running 2 miles the whole time? Or did you prepare for it by maybe occasionally running 5 or 6 miles so that on the race day, that 3.1 was like, I've done this and then some, right? The longest I ever ran was a half marathon. This was years ago. And that's 13.1, I think, 26. Yeah. So I made sure that during the practice, during my training, I ran a couple of times 16 miles, right? So when I was running that 13 and the worst part of it, the last few miles, I could say, I've done more than this. I've done more than this. Hang on, right? So train that way, right? Try to train harder than than the test is actually going to be. So that's kind of the idea here. Good. Anybody have questions? Remember, your best chance of success here, it's just better to be proactive. Make sure you don't just casually, reactively think, oh, I don't have a question. Try to make a question. Try to come up with them and bring them to class. That's going to benefit you the most. So I want you to bring me questions because I know there's some in there. You just have to be intentional about it. Okay. So we left off with chapter 2. Who enjoyed reading chapter 2? You can hold a hand up in the window. Okay. Yeah, that's what I thought. Who thought, oh no, what have I gotten myself into? Chapter 2, that's like boot camp. That's the drill sergeant yelling at you in the face. Get down and give me 20. You really get introduced to some significant legal terms, and it's interesting. But we're going to hopefully clear a lot of that up for you today. Tell me in the chat, just for fun, tell me some terms that you ran into or some concepts, topics that were kind of maybe intimidating, or, oh, what is this about? Yeah, estates, trusts.
There's lots of different, they're the same word, but just added one word different.
And simple.
They sound almost the same, that it makes it really confusing when you're reading those quiz, because it's like you forget about even like the gross, like the easements and all the different ones. That was confusing.
That's a good point. Yeah, that really can be confusing. It sort of reminds me of that warning we gave you about provisional broker versus full broker. How they're going to talk about a full broker just with the word broker, and it's going to be real easy to accidentally in your mind add the word provisional, because you're going to be thinking of maybe the question before asked you about a provisional broker. The following one asks you just about a broker. You've got to switch it in your mind. Oh, wait, this is talking about a non-provisional, even though the only word I'm seeing is broker. Real property. We talked about water rights, literal rights, and riparian rights. Which one does riparian refer to? What am I talking about when I say riparian rights? There we go, Janina. Non-tidal waterways. What would a tidal waterway be? An example of a tidal waterway. Yeah, ocean, the ocean. Even a large lake like the Great Lakes, when they get that big, they do have tidal action. They've got some tidal behavior going on. But the riparian rights are non-tidal waterways, and there's two nuances there. Is it a non-navigable body of water, or is it navigable? Because the difference is how much of it you own. If it's navigable, you don't own any of the water, just up to the edge. If it's non-navigable, meaning no canoes or boats can traverse it, then you own all the way to the middle. I think of maybe a country farmland type property, and the stream is the borderline between two neighbors. And those neighbors, it's a non-navigable little stream, and they can actually walk across it, maybe ankle deep, right? And so they walk out to the middle, and that's where their line is, right in the middle of that stream. Here's our literal rights. And on this one, the tides come in, and that high tide line is the furthest the water comes into, and that is your property line. That's the high tide line. Anybody gone to the beach yet for vacation this year? Hands up in the window. I've not. The wife said, could we go on vacation next year? And I felt bad. Yes, sorry, working too much. I guess I'm gonna need to work something in. But I'm seeing all the pictures of everyone else's beach vacations on Facebook. We saw some concepts of gaining land by some phenomena, and one of them is accretion, soil being deposited by the water receding when I think of moments of drought. The shoreline recedes, the water like Norman pulls back, and you see that band of red clay around the edge. That extra land that has been exposed is a concept of reliction. Water has receded and revealed the land, and so that owner has gained that land. Not much they could probably do with it, but it is a legal term you should know. Accretion and reliction in erosion and avulsion. The tearing away or the gradual wearing away of land. The gradual version is erosion. I think you're all used to seeing that. And the sudden wearing away is avulsion. We got into this big topic. This is a major one. This is one that you're going to want to really get your hands around. Fixtures, concept of fixtures, because this extends beyond this course. Some of the material we cover in this course is to help you pass the exam, and you probably will never see it again. But other material of this course is day to day. This is daily stuff. Fixtures you run into every transaction, right? Got to make sure the seller left the chandelier if they were supposed to, because it's a fixture. If they want to take it with them, fine. Let's just write it in the contract stating as such, so that when you take your buyers for the final walkthrough and it's missing, you have something to stand on. Your buyer says, wait, the reason I bought this house was that awesome chandelier and it's gone. If you don't have it in the contract, because tell me this, sudden pop quiz. What if the seller's agent, listing agent, they posted in the multiple listing service description, you know, where it says the price and the bedrooms and the size, all the stuff about the house with all the lovely pictures and the tours, the multiple listing service data sheet online. And in that description, in the remarks section where it says lovely, 5-bedroomed, 3-bath on gorgeous, lush green acres and gleaming hardwoods, all those terms, you know, all the terms. Chandelier. Wait, let me think. How should I ask this? Okay, no mention. Well, maybe they do mention the chandelier and it's in the pictures, but then okay, sorry, let me back up. It says chandelier does not convey. That's how I want to ask this. Chandelier not included. Maybe in the fine print in the MLS sheet, it says the chandelier does not get to go along with the house. Sellers want to take it. So then a little bit later, a buyer makes an offer, and in the contract, nobody remembers. The agents don't remember to write up the chandelier being something that does not convey with the house. It does not stay. In the MLS, the seller's wishes to take it with them and leave were communicated. But in the contract, it didn't make it. Nobody thought to write it in the contract. So on the walkthrough, when the buyer's agent and the buyer come along, that chandelier's gone. What are the odds that that buyer's going to get that chandelier returned, put back in the house? Where does the law stand? Whose side is the law on in this situation? The MLS said it was going to stay. It was going to, there you go. That's it. Thank you, Twee. It's whatever's in the contract. The MLS doesn't matter. Even though they said what their wishes were, if it didn't survive the contract and get into the actual contract itself, think about Judge Judy. Anybody ever watch Judge Judy? Any court TV? What do they say when somebody disputes with each other and they say, well, we said we were going to do this? She says, where is it written down? Where's the contract? Well, we just promised it. It was an honorable agreement, verbal. Get out of here with that. Not interested in your honorable verbal. I can't do anything with that. We'll learn a word in another couple of chapters called enforceable. Not enforceable if you don't have it in writing in the contract, right? So this fixture stuff comes up a lot. Hopefully not to that level, but it certainly could. We certainly want to be thinking about it when we're showing the property. Certainly if it's fixed, if it's tied down, attached, screwed in, and our client likes it, we want to make a note and think, let's be sure we handle this fixture thing properly. Sorry. There we go. Get some camera action going, because it's a big deal once we get to that walkthrough moment. So make sure everybody knows what's allowed to stay and go, and everybody is on the same page for that. So what is it? What is a fixture? Well, the official legal definition is summed up with this acronym, IRMA, like Hurricane Irma. The intention, the relationship of the item to the property, the method of annexation, how's it attached to it. If it's hanging on a nail, not a fixture. If you could just lift it off like that picture on the wall behind your head, I'm just guessing that you might have a picture on the wall behind your head, not a fixture. Well, we'll get into a little nuance there in real life in North Carolina, but I don't want to confuse you. For the most part, if it's just hanging on a hook, that is not a fixture. Adaptation to real estate, another component of this acronym. So keep IRMA in mind. If it all comes down to it and goes to the court, this would be something the the judge would consider. They would say, does it meet these definitions, whether it's a fixture or not? Run into fixture problems a lot with window treatments, the hardware, the brackets, the rods versus the curtains themselves, the drapes, the actual fabric. What's the difference? It depends on historically. Now it's a little more clear in the actual standard contract we use. I won't get into that, but historically it was a big problem. Are the curtains included, or the hardware, or neither, or both? And you better believe if that seller wants to take it with them and they want to also leave it up during the showings, that's going to become a problem. Murphy's Law, if something could go wrong, it will, says that that particular buyer that comes along is going to end up being the one that likes those curtains and wants to take them or keep them. So you always kind of give the advice, well, if you're going to keep it, get rid of it, take it down now, box it up, don't show it to the potential buyer because it will be an issue. Here's what fixture definitions do not depend upon. And I drove by that house I mentioned to you the other day, but by the time I realized I was right there in front of it, I couldn't pull out my phone quick enough to snap a picture. I wanted to get a picture of that giant fountain I told you about in the house next to where my dad grew up. And that fountain is enormous. And now it's painted black and white. It's like white with these black highlights on it. And it's probably 8 feet tall. It's bigger than I remember. It's huge. I'm sure it was heavy. I'm sure they had to bring it in with a forklift. But does that matter that it's heavy? That has nothing to do with whether it is actually a fixture. Because me and you can't lift it together as two humans doesn't matter. We could lift it with a forklift, a bobcat or something. So the weight, the size doesn't matter. The value of it, it costs $3,000, has nothing to do with whether it's a fixture. And the location, none of these things matter about the fixture definition. It goes back to IRMA. So don't let them try to confuse you in the test question. They might present this elaborate story narrative about what this fixture is, and it'll be tempting. Oh gosh, it's worth $3,000 and it weighs a ton. Well, if it's just sitting on a concrete slab, not bolted to the ground or that slab, then it's officially probably not a fixture. So obvious how it could become a point of confusion. In real life, to avoid the confusion, write it up in the contract, even if it's redundant, even if it's obvious to everyone. Oh, this should be a fixture. This chandelier, this dishwasher screwed into the cabinets. If it becomes something, if that buyer says, oh, I've always wanted a dishwasher, it's the drawer kind of dishwasher, I've always wanted that, let's just be safe. Make sure they get that thing that really got them excited about that house and write it up. And you could present the offer, and the listing agent could say, well, I see you wrote the dishwasher in, and well, you know, how many years have you been in the business? You didn't have to do that. That's okay, I can understand you're trying to flex on me, but hey, it's important to my buyer. We're going to be redundant and careful. And Neal said so. So I'm writing it in, right? Do what you got to do. Ignore their remarks about years in the business. Oh boy. If an agent starts bragging about their years in the business, sometimes, you know, just because you were in it 20 years, you might have been producing and acting like a one-year agent 20 times over. Oh, that means you didn't get any better for those 20 years. So don't let that intimidate you. The good part you have as a newer agent is you know the laws and the rules probably better than everybody else. We need to be intentional about communicating the items intended for removal. What is fixtures? What is personal property? As with all good rules, there are exceptions. And trade fixtures is one such exception. Has the word fixture in it. One of those examples. Oh, could we at least even name it differently? Do we have to include these words and make it 180 degrees different? So trade fixtures are not real property like normal fixtures are. They're personal property because a trade fixture applies to commercial real estate. It's personal property owned by the tenant and that they get to take with them when the lease is up. It's kitchen appliances. It's hair salon sink stations, all of which, you know, your sink is plumbed in. That's about as fixture as you can get. You can't steal that sink from them without a wrench, right? So it doesn't matter. It's a hair salon. Therefore, if that tenant owns it and they're going to take it with them when they leave, what they came in when it started, they came into that space and it was just one big blank room, and they upfitted perhaps all those stations and all those sinks. So they get to take them, and that's a lot of money in those sinks and those stations and kitchen appliances, commercial level. They're attached to the space, doesn't matter. They're trade fixtures, not just plain regular fixtures. Therefore, they're considered personal property, and they're going to be removed at the end of the lease. Then we have another thing. You just learned about trade fixtures in commercial, and now we're talking about agricultural side of commercial. But these fixtures are real property again. So agricultural fixtures are real property, meaning attached to real estate, goes with the real estate, just like the IRMA fixtures, the traditional definition. Agricultural kind of goes back to that idea. It's a tenant, the farmer's renting the land, but these agricultural fixtures stay with the land, stay with the property. When that tenant leaves, they leave those items. They're owned by the property owner. It's real property, cannot be removed by the tenant. Another thing we talked about is that gorgeous set of appliances that's in this house for sale that all matches. It's the renewed, in the 60s, it was avocado, it was mustard yellow. Now they're trying to bring that stuff back. Anybody seen that stuff? Seen those colorful appliances coming back and the tile? Well, say that you got excited about it and you bought a whole kitchen worth of $30,000 matching appliances, but you couldn't quite afford it. But you could afford the monthly payments. So you let them talk you into the card, put it on the card, and you don't actually own those things yet. You're going to own them in 5 years, however long your loan term is. But if you sell that property in the meantime, that entire balance has to be paid. You can't sell the property and continue to make payments on those appliances. That's one of the things that's going to happen with your proceeds from the sale if you're that seller. Got to pay up the balance remaining, that remaining $18,000 on that credit line. Hopefully your agent reminded you of that when you were looking at the bottom line. So we're on 24 with this UCC code, by the way. That's on this same page as this agricultural fixture item. While you owe money on a fixture, it is not real property. It is still considered personal property. So a finance fixture is personal property until paid in full.
Neal?
Yes.
I think I'm confusing myself with that one because we did talk about that last time. So I think we talked about maybe a refrigerator. I'm not sure, but let's say you just bought this brand new fridge and then all of a sudden you decide you're selling your home, but you financed it. Can I not take my fridge with me and continue paying for it if I replace it with another one?
That's a little different because the refrigerator is not a fixture.
Okay, gotcha. Okay.
Because most refrigerators, you just push in the space and plug them in. If it's the kind of refrigerator that's screwed into the cabinets, that would be real property. A normal average refrigerator, not even considered a fixture ever.
So that's not something in North Carolina, because someone told me that fixtures in a home under North Carolina law and that it was supposed to stay, like along with other things in the kitchen.
You're saying someone told you the refrigerator is supposed to stay in North Carolina?
Yeah.
That's an example that I think maybe it was John mentioned to you. Don't listen to anybody but me.
Okay.
Right now for the next 10 weeks.
Never, 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 never.
Advice. You give that free advice. In fact, pay them to take that advice back.
Okay, thank you.
Refrigerators, the rule of thumb, it seems like about half or maybe 80% of the time the refrigerator, I don't even know, but it's a personal property item. It is never a fixture unless it's the kind that's like a sub-zero expensive one that's attached to the cabinetry. Your average refrigerator, even though it's heavy and only one person can't exactly maybe move it out, doesn't matter, doesn't depend on weight, does it? So that person was wrong.
Okay, I was just asking because our last house that we just sold in May, in the contract, they asked for my fridge. They even asked for my curtains. I had to leave my curtains behind. And
Oh,
I was like really upset about that. I was like, why do you want my curtains? The next owner is not gonna, they're not even gonna use them. But I
well,
had to leave my curtains.
you didn't have to. You could have said no.
It was in the contract.
Oh, it ended up being in the contract, but you signed it.
It was in the contract.
Well, you can, parties, and we'll get into this in chapter 9, parties to the contract can strike through things and make changes. And if they agree between them, seller and
I didn't know that. I hadn't met you yet, Neal.
that's it. Yeah, it could have been changed. Everything in there. It's just that we agents can't get crazy and legal and start changing stuff. It's got to be the client says, I don't want to do this. I'm not doing it. Strike through it. I'm initial. But good question. Good point. So the average kitchen these days, the refrigerator is personal property. The range oven, probably shouldn't get into that. In North Carolina, it's officially called a fixture, even if it's just a plug and play. But for your purposes for this test, IRMA rules the day. Follow the definition of what is a fixture by the IRMA acronym. Dishwashers, they're usually, installed into the cabinet. So that's a fixture. Range microwaves over top of the range, they're built into that upper cabinet. That's a fixture. That kind of an idea. Sinks, that sort of a appliance situation. It's not easy, right? The end of the day, it's not easy to tell necessarily what is a fixture because you may not know that that dishwasher has a loan balance on it and therefore is personal property. The point is you've got to ask. And as a broker, it all comes back around to what do I need to know as a broker? And as a broker helping a client to make sure that they are protected, you need to know, oh, wait, don't get excited about that matching client's set. Let's be sure it's all going with the house, Mr. Buyer, right? We got into this one, the manufactured versus the modular home. What needs to happen to this mobile home, also called manufactured, also called trailer home? What needs to happen to this? There are 3 steps in order for it to be converted to personal property over to real property, from personal over to real property. I'm seeing everything. I think we're almost got. Yeah, there's that last one was mentioned first. That's important. Yeah, I think we got them all now. Take off the hardware, the hitch, the wheels, the axles. Yeah, we got that. Attach it to a permanent foundation. Good. And then don't forget this part, cancel with the DMV. I had a closing that was held up by a month because the house was a double wide and the owner had never canceled it with the DMV. And it was actually not that double wide was not what was being sold. He was buying one of my listings, but he owned the double wide and he needed to refinance it to pull money out to use for the down payment on the one he was buying, which was my listing. And that double wide, he had to refinance it real quick. It had never been canceled with the DMV. So people do it all the time. Didn't affect him living there. It just affected the transaction when he wanted to get a loan against it. We'll talk about second mortgages and a home equity line of credit and all that good stuff in chapters 14, 15. So that was it. That's what needs to happen. Otherwise, it's still considered personal property. You rolled it in there, you pulled it in from a truck with a truck, but you got to have these 3 steps. And that makes it different from this thing. Makes it different from a modular. Somebody asked me yesterday over lunch, we're thinking about buying land. What do we need to do? And I went into all the concerns and questions and issues come up like septic tanks and digging wells. And I said, you need to probably, unless you want to do it, hire a contractor to manage all those subcontractors. You could also do it a lot faster and just buy a modular home. And we talked about the difference between modular and stick built and mobile or manufactured homes. So we've got this. Let me see if everything wants to cooperate. Let's see. Okay, we've got this and that. We've got some choices here. Could have a stick built home, which is, bringing in the 2x4s one by one. bringing in the windows and doors and all the elements, and you're just literally pouring the foundation, you're building the walls piece by piece, putting on the roof. Even if the roof comes in those trusses that kind of looks like this, you know, it's got all the sort of crisscross members, that's still considered a stick-built home. Then you've got the manufactured home. You see, I write like some people say I write like a doctor, which I like, but some people say it's more like a serial killer, which I don't like. That's not as much of a compliment. Manufactured, we just talked about, remove the stuff, the hardware, wheels, hitch, axle, attached to foundation, and then register it with the DMV that it's now immovable. It is now no longer portable. There, I can see your faces. And then this thing, modular. When does the modular become real property? You see, this modular is brought in on the back of a semi, and it comes in big chunks. Like this chunk might be the kitchen and the family room and maybe a bathroom. And then this chunk over here might be a couple of bedrooms. Oops, random. Couple of bedrooms. And then there might be one over here that's the other bedroom and maybe the office and laundry. And they put all those pieces together, boom, like this, and put a roof. It's already got the roof built in, and they stick it on that foundation, and boom. That's the point at which it becomes real property, when it is permanently attached. No DMV required. They never had anything to do with it. DMV was not part of the deal on a modular because they don't have to have it registered. It's riding on the back of a truck. It is not the trailer itself. With the manufactured home, it is the actual trailer. It's got its own wheels. Some might say that modular home is built even better than a stick-built home. It's got to ride over the road. It's built in a warehouse out of the elements. I've seen some stick-built homes that take forever. And by the time it's all completed, some of those early pieces of wood they installed were all gray and warped. Right? So it's considered real property when it's assembled on site. If a mobile home is on a parcel of land that is being transferred just means conveyed or sold from one party to another, what would we as the broker do? What do we need to do immediately? We're on that listing appointment. We're at a lovely house. We got excited when we pulled up. It was a pretty house, maybe a mill house restored. Then we look in the backyard and there's a mobile home, an old single wide. They lived on that while they restored the house that they want you to sell. But this single wide is on there too. What do you need to ask them? It's the important question to ask. Tell me more about this mobile home. There you go, Twee. Tell me more. Does it have the hitch and the wheels? You might even be able to see that part yourself. Oh, I see that it still has the hitch. Okay. So we just need to be careful how we refer to this thing. Somebody wants to try to get financing against it, it's going to be a problem. It's not real property. You see the hitch and the wheels and the axle. That's one of the most important, one of the three elements. Oh, what if you don't see those things and it's attached to a brick foundation? You still need to ask a question. You say, did you cancel it with the DMV? Did you register the affidavit with the DMV telling them, look, this is no longer portable. This is now going to be real property. Please give me confirmation that you're acknowledging this. So find out if it's real versus personal. And here we go. Buckle up. Here comes estates and real property. We're not talking about Dallas, the old TV show with the hundreds of acres, thousands of acres, that kind of estate. We're not talking about your favorite celebrity or athlete's estate. We're just talking about how someone owns a piece of property, even if it's a mobile home, a real property mobile home. That involves estates and real property. Do they own it? In which way? Which way do they own it? It's the amount of interest or the kind of interest someone has in a property, not money interest, not like interest in principal, but their consideration there. That's another money work term. It's what's the category of ownership, the degree, the quantity, the extent of their interest in the property. Includes the future rights of possession, the present rights of possession. What can they do with it? It's a description of that bundle of legal rights. Remember, real property? It's the land, it's the stuff on the land, the improvements, but it's also the bundle of legal rights. That's what we're talking about with estates and real property. What can you do with it? Or what must you not do with it? Because it involves that too. It's not a description of the property. It's a description of the rights you have in the property. So, overarching categories, the two main categories of estates. Do you own it or do you rent it? Freehold is ownership. You own it. That's what we're going to talk about in depth today. In the future chapters, we're going to get into leasing, a little bit of leasing, talk about what it is like to be a renter or a landlord. That's called non-freehold, just the opposite of freehold, right? They just like provisional and non-provisional broker. Talking about freehold and non-provisional, freehold and non-freehold estates. Another word for non-freehold is leasehold, because that's literally what it's talking about, is leasing, not owning. We'll get into that in chapter 11. Now, let's embrace this ownership idea of a freehold estate. A couple other categories that might help you. Is it, there we go. Is it able to be inherited? Is it inheritable? That's all that word means. Inheritable, 5 syllables. Those are scary. Those big words are scary. But all that means is, can you leave it to somebody you love or don't love? Can you leave it to someone? Can it be inherited by someone? And that really gets into that whole life estate concept. We're going to talk about conventional life estates and some other things. The inheritable kind of estates are these. And this, I'm going to show it to you on a diagram, because I think like a chart diagram that kind of helps me remember things a little better. The inheritable version of freehold estates include absolute, the term fee simple absolute. Just get into that now. So think of it this way, and maybe write your own chart, maybe all together right now. Freehold estates. And you remember that it's ownership. This is when you own things. Okay, we've got inheritable kinds of estates over here. You can leave these to your heirs when you die. Then we're going to have non-inheritable estates over here. You cannot leave these to your heirs when you die. So of the inheritable kinds of estates, the very best one of all of these, in terms of how much ownership, how much authority you have, what can you do with it? Best one, best choice by far, if you have a choice, is fee simple absolute. That word absolute, pretty good tip, pretty good hint. Oh, absolute. Ooh. Fee simple, don't get caught up in that. Just think of it as a term. It's just a term, whatever. When you see the word fee simple, just think, oh, we're talking about estates. You don't need to deep dive into that. It's no different than saying Mr. or Mrs. or red or blue. Fee simple, what kind of fee simple? Absolute means no conditions. You can do with it what you want. Now, let me qualify that a little bit. Obviously, you do have to follow the law. You do have to go along with the zoning laws, the HOA rules. If you live in a house in a neighborhood with a homeowners association, this doesn't mean, oh, I own this fee simple absolute, and you say that I can't paint my door purple. Well, I'm going to do it because I own this fee. No, you also decided to buy in there subject to their rules, that's a whole different issue. We're just talking about the bare bones legal category of freehold estates. So fee simple absolute, besides the laws of zoning and private land use controls, that sort of thing, besides that, you can pretty much do what you want to between you and the person you bought it from. There's no outstanding conditions that you have to follow. You just bought it to do with as you wish. You bought it from a seller, and that seller did not give you any sort of rules and say, well, I'll sell it to you, but you have to do this, or you're not allowed to do this. That concept of you have to do this if I agree to sell it to you, that's where we get into this next kind, fee simple. And this is probably the first point of confusion that you ran into when you read it. Fee simple defeasible. When you see that word defeasible, I want you in your mind to replace it. And I want you to think of it as defeatable. Meaning, you bought it from this seller as a fee simple defeasible estate. That means that you are agreeing to something that seller is requiring of you. They're saying, yeah, I'll sell it to you only if you always use it as a church or always use it as a farm. Sell it to you, you'll never put a liquor store on it or a convenience store or a bar. These kinds of rules and requirements, that's the difference between fee simple absolute and fee simple defeasible. So again, defeasible is a word I had never seen in my whole life until 1996 when I took this class. And maybe you too. Don't worry about it. Take these words and think of this word and realize, oh, defeatable. It can be defeated. In other words, you bought it from that seller agreeing to their demands. Okay, I promise I'll keep using it as a farm. And then maybe 10 years down the road, you think they're gone. They're not checking up on me. Yeah, okay, I signed some paper saying I was never going to use it I was always going to use it as a farm, but I'm going to sell this thing and I'm going to develop it and use it as something else. They're never going to know. Well, if you do that thing, if you do break that agreement and they find out, you could lose your ownership of it because your ownership of it was fee simple defeasible, meaning it could be defeated if you break the rule that you agreed to. If you ended up using it as a thing you weren't supposed to, or if you did not keep using it as a thing you promised to. And I know the question in your head. Yeah, but how are they going to know? What are they going to do? Are they going to send the sheriff to throw you out and evict you? Doesn't matter. We just need to know the definition and terms. The process of that whole thing, it's a legal process involves suing and this and that and the other. Irrelevant. You just need to know these words and what they mean. Don't get caught up in the yeah, but. When you catch yourself thinking yeah, but, and all this extra information, you're getting in trouble. You're kind of going off the rails and it's going to just cloud up your chances of success on the test. Keep it simple. They're going to test you for the terminology. You don't need to know all of that extra stuff. In real life, as a broker, if this stuff comes up and people say, yeah, so I want you to list my property, but the thing is, I bought it fee simple defeasible as a farm. And in the last 5 years, I have stopped farming altogether and I want you to help me sell it, but I want to carve it up into lots and sell it to different people to build on. You should know enough about this topic in that moment to think, ooh, I don't have a quick and easy listing here. This person needs some legal advice right away. I may not even be involved because it sounds like they've gotten themselves in trouble. So you need to refer them to an attorney to help figure out their mess and whether or not you can even be involved and list the property, because it sounds like they might have violated their fee simple defeasible ownership and they might be subject to losing the ownership. Yes.
So, okay. So like in a case like that, if they should decide to sell the property, does that same fee simple defeasible concept go with the next owner?
Yeah, that's what they have. That's the way they own it. They own it subject to this fee simple defeasible. That's the only, they don't have fee simple absolute that they can give to someone else. They just have fee simple defeasible. So that's a big deal. So when you agree to buy from that seller as fee simple defeasible, you're not just saying, yeah, I'll use it this way. You're saying I'll also only be able to sell it this way in the future.
Oh my God.
Yeah. Big
Okay.
deal. Now it's not something, as far as I know, well, it's not something I can say this. I'm not something I've run into in 26 years firsthand. I'm sure it happens occasionally. And again, the minute you see these words, if you see on the deed, the title to the property, something like fee simple defeasible subject to a condition subsequent, then probably good to reach out to an attorney friend, a closing attorney you use a lot. Margie's never seen it in 50 years. That's good to know. And let's get their opinion, right? Let's make sure that we have full scope of what's involved in this thing. Yeah, okay, go ahead and get excited that you might have a listing, but ooh, I saw that defeasible word means their ownership might be disqualified because of their behavior. Did they agree? Did they follow the agreement? Right? Okay. So fee simple defeasible. Think defeatable. It can be defeated. That owner could lose it because of something they do that they weren't supposed to do. And here are the two categories of that. Fee simple, defeasible, determinable. Let me write it in a different color. Might help. Determinable. Oh boy. Couldn't they just at least use a different letter word? I remember things with same and different letter words. They didn't even have the dignity to give me a different letter to work with. And so you would actually see it referenced this way: fee simple, defeasible, determinable. This whole long drawn out phrase. On the test, you might just see the word fee simple, determinable, but it's a version of fee simple, defeasible. So this is the main category, and this is a variant of that. There's one variant or option under it. The other one is fee simple, defeasible, subject to something. Subject to what? Subject to a condition subsequent. I know. I feel your pain right now. It's like, could you make this any more nonsensical? Those two categories fall under fee simple, defeasible. That's why I like this chart. You know, you can just think of it in the terms of got this thing, and we have this thing over here in a minute that I'm going to talk to you about. Okay, let me get my mess cleaned up. So what's the difference here? Fee simple, determinable. Anybody hanging in there with me? And in the reading, you remember what the determinable one talks about. Fee simple, determinable. Yeah, there you go, Twee. As long as you own it, you got to keep using it in a certain way. So determinable, think so long as, like Twee said, or think must keep using as. And the great example here is farm, must keep using as a farm, must keep using as a church, that sort of thing. If you stop using it as a farm or as a church, then you could lose your ownership of it. The other piece that you need to know here is what happens if you stop using it as a farm. Your ownership of it is automatically going back to the person you got it from. Don't get into how that happens. That's a legal process that you will not be tested on. Just know that it is automatic compared to the other one. The other one is not automatic. In other words, you might get away with the other one a little easier because that owner might not find out that you did this. Let's talk about that other one. Subject to a condition subsequent. That's a negative. That's sort of a, think of a negative term when it comes to that one. Meaning you must not. use it as a thing. I don't know. I'm getting a little colorful. I don't want it to be confusing, but I'm going to do this anyway. Okay. It reminds me of my favorite flavor of icy pop. I like that green one. Must not use it as a certain thing. And a classic example, especially here in the Deep South Bible Belt, is no alcohol. Must not use it in a way that serves alcohol. As an example. When you do that one and you end up, oh, they're gone. They're long gone. They'll never know. I'm going to go ahead and put this bar and grill on here, develop it, sell alcohol. None of their business. I'm the owner. Not really. You're the owner, but you own it fee simple defeasible. You agreed to that. It's in writing on the deed. Therefore, you must not use it to serve alcohol. And now you're making that decision to do so. It's not automatically going to revert back to the previous owner, but if they find out, they could sue you and say, look, they agreed to this. They bought it from me with these terms and conditions. Okay, judge, I want it back. That's what we mean by not automatic. They'd have to go after them in court. Court's probably involved either way, but this is what you need to know for the test. The condition subsequent variant is not automatically flipping back. The determinable one is. Let's look at it in your slides. Now, does this look a little better under inheritable? We've seen these three words: fee simple absolute, fee simple defeasible, and in a minute, we're going to talk about this weird French term. The non-inheritable one we haven't gotten to yet either, but let's look at the ones we've talked about. Fee simple absolute. You have all the rights in the property that there possibly could be. Complete ownership to do with as you wish. No previous seller has put any sort of limitations on you. You're unlimited. It's inheritable. You can leave it to your heirs. It's complete ownership. It's the highest form. In a perfect world, this is what you want to see. This is the best way to own it. You love that fee simple absolute term. If you agree to list a house and you look at the deed and it has this term, you're going to think to yourself, okay, let's see what's going on. We need more information. There are limitations on that owner's rights. Your seller might want to sell it, but let's make sure that they behave themselves so that they still actually own it, right? This subject to a condition subsequent is the one that's the negative. Must not use it for something like alcohol serving. And then the determinable one is must keep using it as a thing. That's the one we did first when we broke it down. It's this one. The new owner must use it for a specific purpose. The owner transfers the property to a church, and that church has to always use it as a church. That church can't get fancy. Maybe the owner transfers it to a little church, and they're just a startup, so they only need a church big enough for 100 people. And so that's what they use it for, but then they get fancy. After 5 years, they're starting to outgrow it. They've already brought in some trailers and some modular units, and they're like, oh, we just need to, and plus, this is not even an area we like anymore. We're too far out into the suburbs, or we want to get down into the city, and we want a nice, big, fancy new sanctuary. So we're just going to stop using this as our church. We're going to use this for something other than a church. We're going to go to a better place for a better, bigger church. It could be that kind of a thing, right? Their ownership could be defeated now because they're no longer using that property as the church. It must always be because they agreed when they bought it. So that was fee simple, defeasible, determinable. Fee simple, defeasible, determinable. You could see that entire phrase. All you need to key in on is the determinable part. By the way, pop quiz. How to ask? Let me think. Is a fee simple determinable property? Is it always defeasible? I know I'm asking a lot. Is fee simple determinable always defeasible? Okay, good. I don't seem to have confused many people. Think of the hierarchy, right? Think of the breakdown here. Fee simple defeasible is two things. It's either determinable or subject to. So yes, fee simple determinable is always underneath and within this category. So fee simple determinable is a type of defeasible estate. Fee simple determinable is a type of defeasible estate. See how, I mean, I think you already knew how this could get confusing, but right, that's why you need to kind of have in your head. And I just think this visual thing might be a case where this visual memory idea is going to serve you better, because you can think of the chart. Oh, wait, at fee simple absolute up top, fee simple defeasible, and then this thing we're going to see in a minute. Within defeasible, there's these two things. That might be helpful in remembering, keeping this stuff straight. The other kind of defeasible was this one. Fee simple subject to a condition subsequent. And all you need to do when you see this is think not. Must not use it as a thing. The owner conveyed the property to a retail center. Conveyed just means sold it. Doesn't mean they just gave it to him for free. It went from an owner to the buyer. So during that transaction, the owner said, by the way, I know you're going to buy this for a retail purpose. You're going to have stores and restaurants here. But welcome to Concord. We're in the South. I'm a church going guy. We don't want you to sell alcohol. Don't get fancy. Don't sell alcohol from any of your retail stores in this strip mall, because that would just be wrong, or whatever they say. Okay. Right. And so that retail center, and this, I could imagine this more than anything else, because it's now, we're talking about a property developer, a commercial use. Going to be real tempting to look at that bottom line and think, I could make so much more if this restaurant can also serve alcohol. That owner's probably dead by now. Let's just go ahead and do it. Right. Right. So not allowed to sell alcohol. Are they going to be able to resist the temptation? So here's where we see what happens if they break the rule. Under fee simple defeasible determinable, which means you must keep using it as a thing, it's automatically reverting back to the owner. Don't worry about how. An attorney's going to handle that. Under fee simple defeasible condition to a condition subsequent, probably the longest title of anything in this entire course, you must not use it as a thing or you're going to lose it, but the owner would have to catch you in it and then take you to court over it, sue you and say, I want this back. You broke my rule under which you bought the property. Doesn't automatically convert back, convey back to the owner. Does that help any? Is that better than reading it? It helps to kind of throw it around, mold it around with your hands like a piece of clay, than to just read these words on the page. This is a classic topic that needs to be worked out and kind of just massaged, I guess, and sort of talked over. So in your study efforts, when you're reviewing, just try to make yourself a chart from memory and make the lists under the various categories and think, and just don't even study it first. Like after we're done today, get a bite to eat, come back, blank piece of paper and a pen, recreate the chart that we've started. We're going to do the whole chart and put as much as you can remember in there. And some of it will be wrong, and that's okay. That's good, because when it's wrong, you're going to remember it better when you find out that it's wrong. You'll compare it back to what you know, and you'll see, oh yeah, that should have been over here. I should have put this under this category. It's going to stick in your memory way better than if you just try to read the pages again. Reading the pages is passive. Making charts and writing notes and drawing and writing things from your memory, that's proactive, and that's always better for learning. Making things, remembering things. That's why at the end of the course, I want you to print the syllabus out fresh again and try to fill it out from your memory, one chapter by one chapter, chapter by chapter. Okay. So determinable and condition subsequent are both types of defeasible estate. So if we look at fee simple absolute, remember that's the best form of ownership. It's complete ownership. It is unlimited, and it is also inheritable. It's in that inheritable category. So we remember that. Then if we come back out, we have fee simple defeasible, also known as, well, the way you can remember it is fee simple defeatable. And then fee simple defeasible determinable means you must keep using it in a certain way. Like it must always be a church. What happens if they break the condition? Automatic reversion back to the owner. And then fee simple subject to a condition subsequent. For instance, no alcohol, no bar ever, must not use it in a certain manner. What happens if they break it? It does not automatically revert back. The owner would need to go after them in court, basically. So both of these things are the category of defeasible. And here's a quiz question for you. A deed or a title to a property that has a condition that limits ownership is called what? Simplest quiz you'll ever have in your entire time here. What is it called when there's a condition that limits ownership? It's almost as if you just saw the answer. There you go. Defeasible. Yep. And we don't know yet. Is it the kind of limiting condition that allows you to, that requires you to use it as a certain thing, or is it the kind that does not allow you to use it as a thing based on this information? Which one is it based on this information? We don't know. We don't have enough information yet. All we know is there's a limiting condition. It could be either one, right? See that point? So you got to think about in the test question, it's going to look something like this. Lewis agreed to purchase a property from Lisa. Upon examination of the deed during the title search, because that's what the attorney's doing, the closing attorney discovers that Lewis's use of the property was limited to using it as a convenience store. In other words, that's all he can do with it. That's all he can do with it. What type of deed does Lewis have? Which of these types of deeds listed below is the one where Lewis must only use it as a convenience store? Okay, and here's what they're going to do. They're going to throw some extra words that start with D. Detectable, we didn't see that. So you're going to have enough knowledge that, oh, that's not even a thing. Forget that one. Strike it out. Fee simple discoverable, again, not a thing that we just learned at all. Is it fee simple determinable or fee simple defeasible? Oh, wait a minute. These both look familiar and they both kind of look right. If you're in this position and you must use it as a thing, that's determinable, isn't it? But determinable is a type of defeasible. So A and D are kind of both right, aren't they? But we need to put another lens over this thing. When you're looking at test questions, you need to read the question with this in your head. Which is the best answer? So which one do you think they're going to want you to know? The one that's the drilled down focused answer, or the one that, okay, yeah, it is defeasible, but more specifically, it's determinable, right? So classic example of that. We eliminated two of them, and most of the time on the test, by the way, you can probably eliminate at least one, if not two, and get it down to a 50-50 chance. Just seems to be the way that goes. Best answer is determinable because that's the most specific, focused answer. What if it had said, fee simple defeasible under D, but then fee simple subject to for A's choice? Now it's going to be D, isn't it? Because A is just flat wrong. Subject to is not the case here. See the point? So just think what's the best answer, and that'll serve you well. What about this version? Lewis agreed to buy a property from Lisa. Upon the title search, the attorney discovers that Lewis can never use it as a convenience store. Therefore, what type of deed does Lewis have? Okay, let's take a look at them. Fee simple conditional. No, that's not quite the word we learned. See, fee simple consequential. No, that's not a thing. Fee simple on D, condition servient. That's not a word we've gotten to yet. Fee simple condition subsequent. That's really the only word that we've seen. So you can get this one pretty easy if you just pay real close attention to the words themselves and not so much, all they did was throw three things that weren't even a thing in there amongst the one right answer. What about this one? Lewis agreed to purchase a property from Lisa. Upon examination of the title, the attorney discovered that his use has no limitations. What type of deed does Lewis have if there's no limitations? Uh-oh. Some A words we've already seen. Avulsion. It's fee simple avulsion. It's all of a sudden it has to do with water. Nope. That's an easy strike it out. No, not the thing. Fee simple alienation. We'll see the word alienation in the future. It just means you're selling it. To alienate yourself from a property means you're getting rid of it, but that's not the answer here. And annexation is another word. See what they do? They throw words that you do know, that you do have to know, but they don't apply to this, but they apply to another thing. So you recognize the word, but it's not the exact use of the word. So fee simple absolute, no limitations. That's the best way to own something. Lewis agreed to purchase. Title search is done. The attorney discovers Lewis's use of the property had a limitation. There is a limitation. What kind of deed is it? Just some kind of limitation. We don't have any specifics. Is it a must not use or is it a must always use? We don't know. The test question is not giving us that information. All we know is it's one or the other. Some kind of limitation. That means we know that it's not absolute. We know that we don't know enough to tell whether it's determinable or subsequent. So that means it's fee simple defeasible. Does that help? Seeing it like that. We try to pepper these in along the way because, again, this is the proactive side of your brain. This is your brain muscle is flexing using this, looking at these questions. It's not flexing so much when you're just reading the content, although you have to do that too. But you need to use it, not just read it. Okay. We talked about fee simple absolute and fee simple determinable. Nope, fee simple defeasible. That's the category. Now, the remaining category under inheritable types of estates is the French phrase pour haute vie. And I'm sure I massacred the pronunciation. We used to have an instructor that actually had a French degree, and she said it right. But some people say pour autre vie. Doesn't matter. The English translation is for the life of another. For the life of another. Let me show you. Let's take a look again at our little homemade chart here. So we've talked about this one. We're done with that. We're done with defeasible. Now, let's look at one second. Conventional life estate is one type of life estate, but that's over here. The conventional one is over here under non-inheritable. We're not there yet. We're going to look at an estate for the life of another. Anybody read about this and think, what did I just read? This makes no sense. Was this confusing? I'm looking at faces, looking for nods and shakes. Okay. For the life of another. So that completes the entire side of this chart that is about inheritable things. This estate for the life of another. You can use this type of estate while another person is still living. It's a third party. There are three people involved. There is the person using it, the person who's buying it, the life tenant. Don't let the word tenant confuse you. Doesn't mean renter in this case. The life tenant is the one using it, or the one who bought it. Wow, puberty returned. The life tenant. There's also the one who sold it to him, right? The seller. There's also the one whose lifespan this life tenant gets to use it for. In other words, the seller sells it to that life tenant and says, you can have this property as long as my grandma is still alive. Let's do it this way. You can have this property as long as your grandma is still alive. The life tenant's grandma lives in a house on the corner of these 5 acres. And the seller is going to sell to that life tenant the right to have that and use that property as long as grandma's still alive so that she doesn't have to move. Shane, it has to do, sometimes it pops up like that because some old person has lived there forever. Let's let them ride it out. Let's let them still live there because it'll make their lifespan the measuring life. I think you see it that way sometimes. And I'm trying to think of some other examples. Yeah, please, Margie. Perfect. Please give us a real world example.
Okay, this is a real world example. My grandmother from Spain, Mama Teresa, had 9 grandchildren. And when we got older, we all lived all over the country. But my one cousin lived near to her. And for the last 2 years of her life, he went to her home every single day after work to help her. So she changed her will. And her will said that for as long as he was alive, he could own that house and live in that house. Once he died, that was to be sold, and then the proceeds would be split amongst the 8 of us who were left.
Perfect. That makes perfect sense. She's trying to give him something, but she didn't want to do her heirs out of the property. So in the immediate future, his lifespan, he gets to have it, use it, own it. And then once he's finished, because it's a life estate. Now this was an example. Margie's example is of a conventional life estate because the life tenant is actually also the measuring life. So let's not confuse those two things. Let's look at it this way. Let me break it down. But we always think that when we're reading this topic, it's like, well, what is the point of this? Why does this even have to be a thing? So if we look on the chart here, this is only life estates. So let's look at these. We've got the for the life of another. And then we've got the conventional life estate. So two kinds. Margie's example was this. And forgive me, the relationship to you was it grandmother, Margie? Grandmother? And
Yeah, my grandmother.
Okay. So Margie's grandmother, her G-Ma, left this property to the one that was taking care of her. And so she was the seller or the leaver of the property, the giver of the property, seller, owner, however you want to call it. And who was the name of the one that was taking care of her that she gave the life estate to?
Jerry.
And Jerry took good care of her and she appreciated that. So Jerry was the life tenant. The life tenant's the one who gets the benefit of it, who gets to use it. And then Jerry was also the measuring life because he got to use it as long as he stayed alive. And then after Jerry passed away, the ownership of this property goes to the rest of them, Margie and the gang, right? And they probably sold it and split the money, I would imagine. Does that make sense? So we've got conventional life estate. The life tenant and the measuring life is the same person. And remember, the conventional life estate is non-inheritable. Jerry cannot leave it to his heirs because he doesn't own it anymore once he dies. And you might think, well, that's stupid. Of course you don't. No, but I mean his estate, Jerry's pile of property, right? His pile of possessions in the form of that old watch that he has that he wants to leave to his son and his car and, also his real estate. This is a piece of real estate that he owns. I just blanked Inheritable, okay, on the spelling. He can't leave this to his heirs. His son, his daughter might have gotten excited at first and think, oh, wow, great grandma left dad this property. How many acres was it, Margie? I always catch you in your sip. Catch you in your sip.
Sorry. It was about 10 acres
10
right
acres.
in the San Francisco Bay Area.
If my dad got 10 acres, I'd be really excited until I read the fine print and realized, oh, I better use it while dad's alive, because soon as dad dies, it's going to my aunts and uncles. Get it? Because dad is the life tenant who gets to only use it during his life. That's what makes it a conventional life estate. Now, what happens when Dad Jerry is not the measuring life? Let's expand on Margie's case here. Grandma is the seller owner. Jerry is the life tenant. And let me think. Who would it make sense for to be the measuring life? For the life of another. I'll think more about it, but for now, let's just say Neal. Me. Because if in doubt, think of yourself. I'm just kidding. Sort of. Measuring life. Now, it's probably a bad deal for somebody. Let's see. Grandma's leaving it to Jerry. Jerry gets to use it and be the life tenant as long as I'm alive. Jerry's going to be thrilled if he's older than me and if I'm in reasonably good health, because I'm going to be alive longer than him, probably. So he gets to live till the whole time he actually is alive, and I'm still alive after he dies. He could leave it to his kids because it's not his life it depends on. Does that make sense? Can you leave an estate for the life of another to your kids? Yes. But what your kids are getting, what Jerry's kids are getting, is an estate for the life of another. They're going to think, oh, he's given us 10 acres, but oh, wait a minute. Don't get too excited. Only going to come to us and we get this 10 acres as long as Neal's alive. Maybe we go ahead and say, hey, Neal, let's take you to the doctor, get a full workup, an MRI, see how you're doing. How long are you going to be with us? Oh, Neal, I don't smoke, but if I did, they would say, oh, you know what? Let's get you in a treatment program. Let's go ahead and kick that habit because we want to own this 10 acres as long as we can. Let's keep you healthy. And I'll say, oh, you're so sweet. No, you're not. You just want to get that 10 acres for as long as you can, right? That's the difference between for the life of another and a conventional. Big difference. Who is the measuring life? If the measuring life is the same as the life tenant, then it's a conditional life estate. And your ownership goes away when you go away off of this earth. Therefore, you cannot leave a conventional life estate, can't be left to your heirs. For the life of another, it is inheritable. Let me finish writing it. And that's why. Because the measuring life is not the one who is owning it, using it. Does that help? Better than reading it in the book. This is one you just have to work through. Another great example of when we're done this afternoon, after you take a little break, take a little bite to eat, try to write these points. Try to recreate this part of the chart, the difference between for the life of another and conventional life estate. Write down who's what. Okay. What about, let's just focus on this side. Let's ignore the conventional for a minute. Talk about for the life of another for a minute. Jerry can leave it to his heirs. When Jerry dies, we're all sad, especially his kids, but his kids get it. It is inheritable. They've inherited it. Can Jerry get a second mortgage on the property? Can Jerry get a home equity line of credit? Could he go to a bank and say, hey, I own this 10 acres. It's worth $500,000. I would like to borrow $200,000 of the equity against this property. I own it free and clear. I want to pull out some equity and go buy something. I mean, it sounds like the safe answer if we were the bank would be nope, because we know that Jerry's ownership of it is only as good as Neal's lifespan. But legally, theoretically, yes. If he could find a lender willing to do it, I don't know how likely that is. If he could find a bank willing to, you'd have to tell him. You could not tell the bank. You have to tell them, look, yeah, that's one of their questions. Let me see the deed. Are you a fee simple absolute owner. Oh no, I'm a poor ought to be owner for the life of another. Oh, so some banks might take a pass on that deal. Other banks maybe. Who knows? So it's legally possible. Yes. Could he lease it to someone? Could Jerry say, okay, I have no need for this 10 acres. I live in the city, but it's got a house on it. And I know a farmer wants to rent the house and farm the land. Could he rent it to this farmer? Sure. What if the farmer wants to rent it for a long time and then Jerry dies and Jerry's kids are still happy with that farmer renting it because they're getting paid. But then Neal dies. What happens to that farmer? He can't use it anymore. So he's got to have the understanding and realize, oh, I'm renting this to use in my business as a farmer, but I'm only going to be able to rent it for as long as this guy Neal is alive. What's his deal? Let me give him some fresh organic produce, keep him alive for as long as I can, maybe, right? So Jerry can still do pretty much whatever he wants with it, as long as the person or entity that he's doing that with understands his ownership scope, understands that he is not fee simple absolute. He is for the life of another, and somebody's lifespan is in the mix. He could rent it. He could do with it as he pretty much pleases. Let's go back to this side and look at some pretty boxes. Freehold estate is limited in life estate. The conventional was the example Margie gave us. For the life of the new owner, the owner grants to the new owner until that owner dies. They are both the life tenant and the measuring life all wrapped up in one person. It is not inheritable. Then we have the inheritable version, which is for a third party. It's about the lifespan of a third person for the life of another. Let's dig into that conventional life estate a little more. Let's refer back to my well-written, well-drawn-out chart here. We've got, we're done over here. Let's forget about this inheritable side now. Let's focus on the non-inheritable side. We've got two things, conventional life estate, which we've already kind of been talking about, and we also have a marital life estate, which we'll get to in a minute. So let's dig into this conventional life estate piece. It is not inheritable. It is temporary. It is only as long as the measuring life is the one that owns it, uses it. It's the life tenant. So as long as the guy who's running it, owning it, is alive, he gets it. Then it reverts. Oh, wait, it reverts. What if grandma did not have Margie and all those siblings? What if grandma never had kids? She gave it to Jerry. Well, she had Jerry, but wait, was Jerry one of your brothers? Okay, he was a different person altogether. Got it. Perfect. Sorry, muted.
We were all cousins, so we were all her nieces and nephews.
Okay, gotcha. That makes more sense. So Jerry took care of her. She did not have anybody else. She only had Jerry. Once Jerry dies, let's say grandma's still around. Once Jerry dies, she's got nobody. She's gone. She has no estate. There's no one or no estate for that property to get turned back over to. Grandma, instead of getting it back, her estate getting it back when Jerry dies as measuring life, she could set it up for a third party to get it. That would be called a remainderman. So yeah, that's a good point, Jennifer, and I see where you're going with that. We're going to get into that. If somebody dies without a will and without any heirs, the state gets the property through what's called a sheet, and that's a thing, and we'll talk about that. In this case, conventional life estate, we've got, get a nice pretty color, stands out. What happens when Jerry dies? What happens when that life tenant, who is also the measuring life, dies? Two things. One of two things. It's either going to revert back to the one that he got it from, or it's going to go to a third party. And that's where you saw another big long word in your reading called remainderman. Don't worry about that word. Just think of when you see that word third party. It's another person. Now, it may not be a person. Grandma might have always loved the charity Boys and Girls Club. Grandma might have said, you know what? I won't be around. I have no heirs. When Jerry dies, I don't want it coming back to my estate because that's really going to be nothing. Let's go ahead and just let it go to the Boys and Girls Club and let them sell it, take the money, and do good. Do some good stuff for kids. She could leave it to a charity. That happens. That's a thing. Probably, maybe even more commonly. So a third party might also be a charity. So who decides what happens to that property when the measuring life dies? The original owner, right? The owner-seller. That's who's going to decide what's going to happen to it. It's either going to come back to them or their estate, or it's going to go to another entity or party or person, the remainderman. So we have lots of fun terms in this topic. Remeasuring life, the one who determines the length of ownership, the lifespan that determines how long you own it. The remainder interest, the third party that it could go to, original owner designates it's going to go to a whole nother party, not come back to them. So it's either going to be remainder interest or reversionary. It's going to be either or. Which is it? What happens to it when the measuring life dies? And this is the same for either a conventional life estate or a pour haute vie for the life of another. These terms all matter in both. You're going to have a remainderman, you're going to possibly, or a reversionary. It's either going to revert back or it's going to go to a third party. Okay. Okay. And then reversionary is when it goes back to that original owner or to their estate. Now, we've talked about everything except the last part. We've talked about inheritable, which was fee simple absolute, fee simple defeasible, which is a complete mess now, and estate for the life of another. All of that is inheritable. Then we talked about non-inheritable, conventional life estate, this piece. Now we're going to talk about the last thing, the marital life estate. Marital life estate. This applies when either the spouse who died leaves no will or the spouse who dies tries to cut out their spouse from the will. They're not divorced. He's just a jerk. And he was trying to leave her out of his will or give her a ridiculously small amount of money. And in North Carolina, she is guaranteed, whatever the spouse is, I'm making assumptions here just for fun. She is guaranteed to get a certain dollar value of his estate based on how long she had to put up with him, based on how long they were married, right? That's how that works. That's what we're talking about here. You don't need to know how long that was. You could Google it if you're curious. And there is actually a chart I've run across before, and it shows, they were married this long, then they're going to get this percentage of the estate. And it's all laid out, and it's different in different states, but that's how it works here. Point is that spouses have rights to the property even if their name is not on the deed. Oh, he bought it when he was single. Then they got married, doesn't matter. That married spouse now has rights. There's a story that I've heard before. And the guy's buddy, the guy was an agent, and his buddy went to Vegas, and he was all set to come back home from Vegas on Sunday in time. No, he was going to be gone all week. He had gotten his real estate buddy to agree, you show up to my closing on Monday, you're going to sell my townhouse for me that I bought. I'm still single. I bought it, my first house. I'm going to give you power of attorney, agent buddy, to show up to closing because I'm not coming back from Vegas for this closing. You go there. You sign the papers for me. Well, he calls his buddy on Saturday and he says, hey, good news. And his agent buddy says, oh, did you win some money? Did you gamble? Win some? No, got married. Elvis got us married. went to the chapel. His agent friend immediately did not celebrate, did not give him a congratulations. He said, wait a minute, you're now married? She's got to sign the papers so that you can sell your townhouse. What? I bought that by myself. She didn't have to sign that. It's mine. And plus, I already gave you power of attorney to sign it for me. Yeah, but she didn't give me power of attorney. You just added an owner into the mix. So Monday is probably not going to happen unless you cut your vacation short and come on back. Because all I have power of attorney for is you. And you just added an owner. See the point? That's what happens in North Carolina with marriage, right? Even if that spouse is not on the deed, they have an ownership interest. They have to sign some stuff. You can't sell without their knowledge. He could not have sold it and hidden it from his newly married wife. The attorney wouldn't let him. The attorney would say, are you married? He'd find out if he's married and realize he is married, and therefore, oh, you need that spouse to sign. Doesn't matter. It's their property, inherited property. I'm seeing that in the chat. What you own and you're married is y'all's, not yours. How about that? How about that for some Southern language? So that's it. The marital life estate piece is not very extensive. It's nothing nearly as involved as conventional life estate. You just need to know that the spouse would have to sign. If a spouse is leaving no will or trying to cut other spouse from the will, they can't. There's a certain legal requirement that the surviving spouse gets a certain portion of the estate based on how long they were married. You don't need to know any numbers. Don't need to know anything past that. Just that it's a thing that exists, and here's the gist of it. Poor Out V, life estate. Let's do that recap when we come back from break and get back on track with the breaks. Let's come back at 11:04. 11:04. Welcome back. We are back. Let's wake up a little bit. We're halfway there. Yay, halfway there.
Who's ready for the rest of class?
Sorry, I didn't mean to scare you.
Yeah, have all the tricks. Okay. Let me show you something. Let's look at your book. We're going to see it in slides here in a minute, but we're on page 31 of your textbook. Oh, good question, Darnell. Yeah, so some really smart, expensive attorneys have figured out how to circumvent certain things. Certainly a prenup could probably outweigh a life estate, a marital spouse's rights is sort of the whole point. But good news is you won't be tested on that in this course. But yeah, good point. That is probably a way to defeat some of that sort of thing. Let's look in your textbook. Hopefully that is zoomed in enough. Some little points about the life tenant component. A little crooked. So look about halfway down. Where are we at here? They can legally mortgage the life estate. They have the right to any income produced by the property, as the focus tries to figure out if it's the words or my finger that it's supposed to focus on. It's unlikely a lender, a bank is going to be willing to loan money against such a property, but it is legally allowed. But they would be responsible, that life tenant, for the principal and interest on that bank note, on that payment. The thing about a life tenant is they can't just lay the property to waste. They can't just clear cut the whole thing, right? They have to keep it in good shape so that it's good when it goes back or goes to the remainderment or reverts back, one or the other. And that's what that last bit is talking about. And notice this last line, estovers, another term to remember. Write that in your notes. The right to estovers allows the life tenant to cut and use a reasonable amount, the famous last words of a legal case. Oops. Okay, let's see if I can get this worked out. Here we go. The right to estovers gives that tenant the right to, life tenant, the right to cut some trees so that he can cut some timber from the land to repair the building or to use as fuel. They don't let them clear cut the whole thing and get rid of all the trees. I can't keep track of which camera I'm on. Which is it? Is it that one? Okay. So know that right to estovers. If they violate the right to estovers, use more than what they need just to repair buildings or to use for fuel, it's called an act of waste. Wasting the property. That life tenant still has to pay the taxes, including any assessments. We're going to learn about assessments. Basically, the city or county can say, hey, we're going to put a street light in front of your house and all the other ones on this road, and you have to pay for it. We're going to put an assessment on your property, and now for every month for the next 2 years, you're paying us $200. That's an assessment. Your homeowners association could put an assessment on your property too, because they're going to re-roof everybody, and it's all townhouses, or right, that sort of thing is what we're talking about with an assessment. Life tenant has to make repairs, we can see right there, and can't let it deteriorate. Now, in a minute, we'll come back to this when we talk about the Homestead Exemption. I'll show you straight out of the book what that's all about. I think the Homestead Exemption is really a big thing in Florida and some other states, but we'll talk about what we do with it in North Carolina. Let's come back and finish up for the life of another. Same as ordinary life estate, same as a conventional, except it's a third party in the mix. And because it is inheritable, you can leave it to your heirs. It is inheritable. You can leave it to your heirs, but only for the lifespan of that measuring life, whoever that is. The life tenant can transfer their interest. They could sell it as long as the person they're selling it to understands that they're only going to own it as long as that measuring life is alive. How about that? Think about that. I'm going to sell it to you as long as you know that you may not get to own it forever. What I'm selling to you is my interest in it, which means I'll sell it to you and you get to own it as long as this other person is alive. They could rent it out. They could use the wood for fuel and repairs. That's where that Estovers thing comes into play. Only for the life of the named person. They have to make repairs, just like we saw in the text just now. They still have to pay the taxes. We're going to see later that real estate taxes are called ad valorem taxes. That's a Latin term meaning at the value of the property, because your taxes on your property is based upon what the government thinks your property's worth. Good news is they usually think it's worth less than it actually is, unless it's reassessed, and then they probably think it's worth more than it is. So these responsibilities of the life tenant are, again, for the life of that named person. And these slides are about which either conventional or for the life of another. It applies to both. The responsibilities apply to both situations. The rights of the life tenant apply to both. They cannot waste the property. They cannot will the property when it's a conventional life estate. And then here's the Homestead Act. States handle it different ways. It basically is it's sort of a version of a life estate in that it's protecting the owner from creditors. The owner, if they maybe start owing credit card companies or other creditors, they don't have to worry about losing the house because of it. That's what the Homestead Act is about. Now, it doesn't mean they can stop paying their taxes or stop paying their mortgage. Those two things they must keep paying. But it's other creditors, credit cards, cars, other things besides mortgage or taxes. The exemptions work this way, and this is it. This is all you need to know about the Homestead Act. There's just this little paragraph in your book on page 32. We'll look at that in a moment. The exemptions are this way. Under the Homestead Act, you're exempt for $35,000 unless you're 65 or older, and then the exemption goes up to $60,000 for older folks. Let's look at it. There we go. And see what I did? I just got nice and messy and wrote in the margins and circled and underlined things. I didn't have a highlighter in the moment. But I wrote out the bullet points in the margin, right? The Homestead Act protects from creditors, $35,000. See, current amount of protection is $35,000. It was before 2009, about half of that. It also increases that protection to the 60,000 point if it's a 65 or older person owner. And then a little further down, it talks about property owners helped by this Homestead Act in the event that judgment liens are obtained by her. So basically, it's judgment liens not including taxes and mortgage. She still has to pay those. That's about it for Homestead Act. Property owner who wants to transfer their property to another and then have it come back to them when that person is finished with it should grant what kind of deed? They want to transfer their property to another, have it returned to them. Put in the chat. Yeah, sorry. What's the best possible answer? Let me give you three choices. Conventional life estate, life for the life of another, or just life estate as a broad category. Which is the best of those three? Because it could be either one, right? That is just something that could be either pour out V for the life of another or a conventional. Could be either one. Want to transfer it to another and have it returned to them. It applies to both could possibly come back to them. The measuring life is not mentioned in this specific question, right? In real life, if these words come up between you and a potential client, get an attorney. Get an attorney in the mix. Probably an attorney you have a lot of closings with. It's going to be your best bet to give your client or your hopeful client a little, maybe a little free advice. Sometimes those attorneys that you have lots of closings with are willing to give you a quick answer, by the way. Call that paralegal you work with a lot. Say, could you check with Kevin? I literally have an attorney named Kevin, and find out this. And usually they'll give me enough to go on to figure it out for my client to make a decision. Obviously, the more elaborate it is, they need to probably pay for some time and get more in depth and talk to the attorney themselves. Okay, guys, that's freehold estates. That's that one of those weird topics. Now let's get into how many people own something. How many? Who here bought a property when you were single? Anybody buy a property when you were single? No spouse involved? Got a couple of you. The word for a single owner makes no sense. What's the word for one owner of a property? Not like two owners, not you and your best friend or you and your spouse. It's just you. You bought it. What is the word for when you buy it? Shane's been reading severalty. And you might be thinking several, that's many people. But don't look at the several word. Look at the word sever. Think of it that way. Maybe that's your remembering device here. Sever. Like when you sever something, there's just that one piece left over. It's usually a gross thing we're talking about with that word. But severalty, ownership in severalty means one person or one entity, which is nice and unclear. But work with it the best you can, right? Bring up a nice, fresh, new board here. Ownership of one person, severalty. Me, myself, and I, right? When it's more than one person who owns it, it's called concurrent. That makes a little more sense because I'm thinking of the Spanish word for with, C-O-N, con, right? Concurrent. Maybe that's how you remember it. More than one person, two or more people or entities. What do I mean by entity in the chat? Tell me an example of an entity. Entity, a legal entity could be known as a what? Yeah, a business is going to want to set up an entity. What's a specific kind of entity? The letters themselves. It's usually some kind of letters. There you go. LLC, limited liability company. LLP, partnership. Subchapter S, C corporation, all that fun stuff. Those are entities. Those have their own identity. You're running them because you own it, but you're the human responsible for it. But that entity is the thing in whose name you're doing the business, right? So that if that customer decides to sue because they got hurt at your business, they're not suing you, the person, they're suing your business entity. And there's that separation of liability. That's kind of the biggest draw, as well as some tax benefits, some tax deductions. So an entity could own property. And if it's one such entity, it's ownership in severalty. If it's two entities, it's concurrent. If it's two people, three people, more than one is the word concurrent. And there's the categories. There's three categories of concurrent ownership. We'll just go in order of the slides for a second. With concurrent ownership, when you own this condo we're looking at on the screen here, you don't get to, I've seen some sitcoms way back in the day where the owners put a tape line down the middle and said, oh, too bad you don't own the bathroom. I own the kitchen, or I own the bathroom. Oh, but I own the kitchen, and they can't cross the line. That's not the way that works. It's financial. It's financial ownership amongst people. They have what's called unity of possession. You get access to the whole thing. You can't keep them from using a part of it. That's called unity of possession. Everybody owns full access, not separate sections of it. So that's a part of concurrent ownership. Okay, I like to do this a little backwards. Let me skip ahead to this version. We were just talking about marital life estates. Now let's talk about married folks again. If you were married and you wanted to buy a condo together or a house or whatever, you're married. Let's do it this way. You're both married for the second time, and you both have adult kids, grown kids, and all of the kids are in good shape financially. They have no problems. They don't need you financially anymore. Probably rare, but let's just pretend in fairy tale land that that's what's happening. If you're both married to each other for the second time, congratulations, newlyweds. Your kids are all squared away. They're not just looking for your help financially. Then how do you want it to be set up if you die? What happens to that condo when you die if you're married to a person? Are you okay with the surviving spouse getting the whole thing? Probably. Probably even more so than wanting it to go to their kids. You're still living there. Do you now want to be co-owners with their kids? Their adult kids? Probably not. Right? So this idea of the surviving spouse getting the whole thing if you die is called right of survivorship. Twee, she is correct. As usual, good job. That's an important component to tenants by the entirety, is right of survivorship. Yeah, the kids get it. No, they don't. Yeah, if it's your kids with them together, you're going to let them still live there, right? They're still your kids, but you own it. You don't co-own it with those kids, whatever age they are. So tenants by the entirety, spouses have this right of survivorship. One dies, the other gets the whole thing. You're not suddenly co-owning it with the adult kids of your spouse you married as second marriage people in life. Probably a good idea for that not to happen to you. You can't force your spouse to sell it. If you're just tired of it, you just want to sell and get your piece of money out of it, you can't sue them for the right to partition. You can't force them to sell it so you can get your piece. That's not allowed in tenants by the entirety. That's another little nuance. It's if you bought the property by yourself and then you got married, the property doesn't all of a sudden, that deed in the drawer of your desk doesn't all of a sudden morph into the words tenants by the entirety. It still says that you own it, fee simple absolute. The words tenants by the entirety doesn't kick in. It's not automatic, but if you buy it together as a spouse, then it's tenants by the entirety. So in North Carolina, by far, the legal advice is if you're married, you should probably own it as tenants by the entirety, but it's not required. It's just the favored form, mostly because of that right of survivorship feature in North Carolina. If you go to the attorney and say, me and my spouse are buying this thing, they're probably going to say, okay, we'll write that up as tenants by the entirety. And unless you want something different, that's probably the way it's going to happen. We'll talk about why you might want it different in a minute. It's automatically done unless you specifically tell them, don't do it that way. Oh, we don't want to do it that way because how about this example? To piggyback on what we mentioned earlier. This time, you and your spouse getting married for the second time, you're, let's say, in your 50s or 60s, and congratulations, you were married before, they died or you divorced, and now you're ready to have another relationship to that level, and now you're married again. And you both have adult kids. But let's say my kid maybe has special needs, or for some reason, we want it set up so my kid gets my portion when I die, not the surviving spouse. Then we can't use this form of ownership. It doesn't allow for that. We would use a different kind, something called tenants in common. And we'll learn more about that in just a second. So you don't have to do tenants by the entirety. It's just probably going to be what most people want to do. Does that make sense? And there are cases where maybe both parties are happy with that. Hey, I don't need it. I got other houses. I don't need to have right of survivorship here. Your kid is important to you. I love that kid. I want them to have, and plus it's a second home. I'm not getting kicked out on the street when you die and all of a sudden you're leaving it to your kid and now I got to go. No big deal to me. In that scenario, no big deal. If a single person buys and then later remarries, the ownership does not automatically become tenants by the entirety. They bought it in severalty by themselves before you came along. Then you came along, it's still owned in only their name. But here's the nuance there. They can't sell it without you agreeing. You have to have awareness. The attorney's going to say, are you married? And they're going to say, yes, but I bought it by myself. Doesn't matter. I need her or him to come in and sign, acknowledging that they know you're selling it. You can't sell it in secret from your spouse. The old phrase is, it takes one to buy and two to sell. You could buy in secret from your spouse, but you better have a different plan when it comes to the exit strategy, because they're going to have to sign off when you go to sell it. But that's not, that's kind of its own separate thing, what we're talking about here. If both people are on the deed and it's not tenants by the entirety, then an option would be tenants in common. We'll learn about that in just a second. So a single person buys property, then later marries. Both spouses must sign the deed to transfer clear title to a new owner. Can't sell it in secret because of the marital rights situation. How do we terminate tenants by the entirety? We own it with our spouse as tenants by the entirety. How could that go away? Well, if one of you dies. Also, you could agree legally. Let's change it. We are tenants by the entirety, but I'm going to make this maybe investment property. Or maybe let's say this. The wife is the real estate person. She's all about the investment property. The husband has the boring W-2 bank job or whatever. He just does his thing. He lets her he just says, you know what? I don't need to know. Just keep me posted, but you're the smart one in the real estate side. You run the show there. So let's convert this property that we own currently as tenants by the entirety. Let's go to tenants in common on it. And you sell it if you want to, if you find it in our financial best interest to go ahead and sell it. And then it's not tenants by the entirety. And if I die, you could own it, but I could also leave it to my kids. Tenants by the entirety allows for that. So tenants by the entirety goes away with legal agreement. You could both agree. Let's just change it over to a different version. It could also it goes away in divorce. That's always fun when you go to a listing appointment and they say, yeah, we're divorced. You show up and it's only one of them there. And then you find out, oh no, well, okay. We've just been separated for 10 years. So we're basically divorced. I don't need their signature. Yes, you do. You're not getting a listing today. You're getting a listing when that spouse, who is still the spouse because they're not officially divorced, they still need to sign the listing agreement, because they're also going to need to sign the contract because they're still the spouse, whether they've been living there or not, whether they're both shacking up with new people or not, and no matter how long they've been separated but not quite yet divorced. But once they are finally divorced, tenants by the entirety is gone. Legal separation doesn't count. Does not change the form of ownership, and people try that all the time. As a broker, you gotta ask those questions. Sometimes it feels like none of your business, but it is most certainly your business, because it depends on whether you have a listing and therefore a sale or not. Just trying to help them. We're going to come back to that. Now let's come back around and talk about tenants in common. So we've talked about married folks are probably going to be using tenants by the entirety. What do they like about it? The right of survivorship. So we have this. Let's look at it this way. By the entirety. It's for married people only. Only married people can own as tenants by the entirety, period. Only for married people. Non-married need not apply. But not required. It's not the only way married people can own. It's just only married people are allowed to have this one. Because married people could choose to own it as tenants in common. Let's see, what else? It has that right of survivorship. That's the most attractive feature to it. You can't sue for the right to partition. There's no right to partition. And then we have joint tenancy. What if people wanted to have that right of survivorship feature, but not get married in order to get it? We've been together for 20 years. We just don't want to get married. That's not what we're about. But we do want to have it so that if one of us dies, the other one gets the whole thing. That's where joint tenancy can come into play, because joint tenancy has right of survivorship too. It has right of survivorship. It allows for unmarried people to enjoy that big advantage of tenants by the entirety, which is called right of survivorship. But with joint tenancy, there is a right to partition. You could sue your co-owner to sell in order to get your financial piece out of it. That's a right to partition. And then we have tenants in common. Let's go ahead and just fill the whole thing out. Tenants in common. That one also has a right to partition. I don't know about my grammar, but you get the point. It does not have right of survivorship. So if you're okay with no right of survivorship, tenants in common is the way to go there. It can be married or not. Married folks or non. Same here. Married or non. So married people can use all three, any of these three. Non-married people can only use two of these three. They cannot do by the entirety. Some other things we'll see in a minute. With joint tenancy, it's equal ownership interest, meaning if it's, let's say this, boyfriend, girlfriend. She's got her act together. She got a job right out of college. They decided to buy a place together. He's still finding himself. She thinks he's pretty, but he's not real responsible. And she thinks that's adorable. And she's putting $50,000 down for the down payment. He's contributing $10,000 for the down payment. She might have a conversation with him and say, "You're cute and all, but I'm okay with living with you, but I'm putting 50 in and you're putting 10 in. You're crazy if you think we're going to be 50-50 owners. How about we go 60-40, 70-30? Or since I'm putting 50 in and you're putting only 10, let's go 90-10, right? Unequal ownership. That's only fair. If they want to do this unequal ownership thing, then joint tenancy is not going to work for them. So unequal ownership is allowable with this tenants in common thing. That's a big reason that they might choose to own it, not as joint, but instead as tenants in common. And this will make more sense when we look at some examples. Another thing about joint tenancy is it is set up only at the time of purchase. Okay. If three of us in this room decide to buy something together as joint tenants, then we can be called joint tenants as long as we're buying it at the same time. Buy at the same time. But what about next year? Me and Shane and Janina decide to buy something together. Next year, she's out. Janina's like, you know what? You guys are messy. I'm out of here. I'm selling my piece to Darnell. Me and Shane are still joint tenants because we bought it at the same time last year. Janina is also a joint tenant until she sold to Darnell. Darnell comes in. He's not a joint tenant because he wasn't here last year when we bought it together. Me and Shane are the joint tenants. Darnell is a tenant in common. That's what that at the same time thing is about, right? So equal owners is joint tenancy, and which means if it's three people in joint tenancy, it's going to look like this. Each person owning 33%. Or like this, two people each owning 50. Going to be equal. If it's got to be unequal, then you can't use joint tenancy. You'll use tenants in common. Okay, let's catch up in our pretty version here. Tenancy in common, two or more people or entities, because it's concurrent ownership. Individual shares can be inherited or sold, we own something as tenants in common together, I can sell my piece without your permission. It can be unequal because you're putting more down payment than me. So let's give you bigger portion of it than I have. It can be acquired at different times. It can be encumbered. I could use my portion, my third of this property, and go to the bank and say, I want to borrow against it. Oh, the whole property is worth $300,000. You want to borrow $200,000? No, because I don't own that much of it. I only own, what would that be? 100,000 of it. Therefore, I'll borrow against my 100,000. It can be encumbered for the amount of your interest in it. And it can be forced. You can force your co-owners to sell so that you can get the money out so that you can take your part and go. So we've got an example of Ali and Beth. They both bought, and they have 50-50 ownership. Beth sells her piece to Carrie and Dante. She's got 50%. She sells Carrie 20% of it. Dante, she sells 30% of it. Ali is still the half co-owner from the original purchase. And so now this is what it looks like. That's how they own it. Maybe it's a 3-bedroom kind of thing. And it started out being tenancy in common, and it continues being tenancy in common. The original purchaser, Ali, was a tenant in common. The new owners, along with him, are also tenants in common. But let's look at joint tenancy. Another side note you'll see probably in your book as well. Joint tenancy, we're going to learn the legal ins and outs of it, but it is not legally favored. North Carolina just doesn't really do it that much. And in order to pull it off and have it become this thing called joint tenancy, the attorney has to really have their act together and know exactly how to write it up properly. Because if they don't use the right words in the deed, the way they write it, then it won't end up being joint tenancy. That's all you need to know about joint tenancy in North Carolina. It's not typical. It's either usually going to be tenants by the entirety for the married people only, or tenants in common for everybody, including married people if they choose to. So it's got to comply with case law, very specific wording in order to be joint tenancy in North Carolina. There are some, another acronym here, Unities of Ownership Interest, PIT, P-I-T-T, Unity of Possession. You own it in equal portions. All 4 of you, each of you own 25%. All 3 of you, each of you own 33 1/3%. Unity of interest, unity of time. You bought it at the same time. Unity of title. So you can't split it up unequally. You have to buy it at the same time. You can force each other to sell so that you can get your piece out of it. And you can do with your part what you want to do. So unity of time looks like this. In joint tenancy, A, B, C, and D people, these are all different people, they buy it together as joint tenants at the same time. But then later, D sells to E, and E now cannot be considered a joint tenant. He wasn't around. He didn't buy it back when all the 4 of them bought it. He wasn't one of the original 4. E is going to be a tenant in common, while A, B, and C still remain joint tenants. That's a very testable question, very testable idea here. In joint tenancy, you must buy it at the same time to be a joint tenant. If you come in later, one of those original owners sells to you, you cannot be a joint tenant. You weren't there in the beginning when it was initially bought. Not a big deal. You're just going to be legally considered a tenant in common. It's not that it's a downside to that, by the way. So we've got joint tenants for A, B, and C, and then E, the new co-owner, is a tenant in common. Survivorship is in place. Here's a fun one. A, B, C, and D buy together under joint tenancy. D has a spouse and kids. D dies. Who's the owner of the property now? There is automatic right of survivorship with joint tenancy. Who owns the property when somebody dies? When you have co-ownership and right of survivorship? The ones who are left, the remaining owners. So if A, B, C, and D own it as joint tenants and D dies, doesn't matter that D has spouse and kids. The spouse and kids have nothing here. The new owners are A, B, and C. In fact, they got an increase. They used to own 25% each. Now they each own 33.33%, because now it's only 3 owners, not 4. Sorry, spouse and kids. Brutal truth in this law of nature here, right? So D, even if they try to will their portion to E, E gets nothing. E has no ownership because there's this right of survivorship. That's how right of survivorship works. The surviving owners get it all, not your heirs. It's not inheritable. Joint tenancy has right of survivorship. That means the surviving owners of this property is who ends up being the owners. Doesn't matter about the heirs. That is very testable. Pulls at your heartstrings. You're like, oh man, that sucks. And what if D owned like the whole basement level? A, B, and C owned bedrooms upstairs, and D lived in the basement with the spouse and kids, and then D dies. Not only now are the spouse and kids not owning it, they got to get out because they don't own it. And A, B, and C are like, we don't own this with you. You got to leave. We got plans for that basement. Sad. That's what this means. Twee, what circumstance were you referring? What were we talking about when you asked that question? What circumstance is this relevant in real life? Joint tenancy. Well, this would be one. If that helps. The other one might be the whole, if you don't want to get married to somebody, but you still want right of survivorship, then you would choose joint tenancy over tenants in common. In real life, though, the attorney can pretty much draw it up however you wish, mix and match and make it custom to your specific situation, but you just need to survive this test. So you just need to know the 3 separate meanings and definitions and bullet point lists of what's involved in these 3 types of ownership. Okay, so tenants in common looks like this. We've got unequal shares are possible. They don't have to be, but they are possible. You could choose to be 50-50 as tenants in common with your other person, or you could also choose to be 70-30% because you're putting more in it than they are. Tenants in common also allows for owning it and acquiring it at different times. And then when one owner passes, the one who dies can leave his portion, her portion to their heirs. They have that option to inherit. What if back here, when D, A, B, C, and D owned it as joint tenants, what if they were thinking about buying, they had not yet pulled the trigger and bought it yet, and they're saying, let's just be joint tenants. D might say, wait a minute, guys, I have spouse and kids. I want to set it up so that they get my portion if I die. Then we can't do joint tenancy. We're going to have to do tenants in common. Right? Probably a good reason to not wing it and do your own legal work. Probably a good reason, good case of when you talk to an attorney to find out why these things matter. So if you want it to be inheritable, be tenant in common. Joint tenancy is assumed to be equal shares, 50-50, 25% each for 4 owners. They have to buy it at the same time. When one passes away, the interest is assumed to be inherited by the other joint tenants. It's probably going to work that way is kind of what we're talking about here. This is just for the test, passing the test. In real life, if these words come up, if somebody ever says to you as a client, I had actually had this happen. I was in a little church band and the keyboard player, she said, I know you're in real estate. I'm an adult living with my mom. She owned the townhouse. I started living there with her in her older years. So it's her name on the deed, but in the meantime, she and I refinanced the house together. It's both of our names on the mortgage, but only her name on the deed, and I have a brother in Texas. Thankfully, she was in a good relationship with him. She really wasn't worried about him causing any problems. But her mom had been having some health problems, and she said, what should I do? I'd like to get on how do I get on the deed too? And since if I didn't teach, I probably wouldn't have remembered these definitions. So since I teach, I said, well, here's what tenants in common is. Here's what joint tenancy is. Here's what tenants by the entirety is. Obviously, that's not an option because you can't marry her. So it's one of these two things. Now, what did I not say to her? I never said, here's what you should do. In real life, you say, here's what they mean, but now here's an attorney to talk to figure out what you should do. And so I gave her an attorney's name and number. And, as coincidence would have it, like within 6 months, her mom got diagnosed with cancer, advanced stage, and within another 2 months, she was gone. And I kind of wondered because I never followed up. I never had reason to follow up. I just gave her the information and she didn't tell me. But another month went by and she contacted me and said, okay, so, Mom, I knew because I played in the funeral. She had us go up there and play some stuff, but she did. Turns out she did reach out to that attorney. She did get her name added to the deed and they did have that done. I think they did tenants in common. So that was nice as far as such a sad situation. It worked out and she got that done as one less big thing to have to worry about. So these are the general differences that will help you on the national exam. These are things that apply to the national exam. You could also see them in the North Carolina section, but just know that the joint tenancy is not something that's favored in North Carolina. The definitions of what they are, those types of questions will be on the national. We talked about this one first because I like tenants by the entirety. I like to lead with that one. So we're good on that one. And we know this: single person buys, later marries. Their ownership does not automatically become tenants by the entirety. They're actually considered tenants in common. And they would have to sign the deed to sell the property. Talked about how to terminate tenants by the entirety. And that brings us to the next topic about houses. Not people anymore. We're going to talk about property. So, real quick, quiz question. Concurrent owners, multiple owners who wish to have the fewest limitations on their ownership interest, would want which of the three types of tenancy? Which of the three gives them the fewest limitations? Because let's think about it. By the entirety is only for married people, and it's got right of survivorship. Joint also has right of survivorship. Common does not. Common allows for unequal ownership amounts, 70-30, for instance. It allows for buying at different times. So tenants in common, right? Tenants in common. That's the fewest limitations. Let's turn our attention to the types of property. Hybrid ownership. We're talking about not single-family homes. We're talking about condominiums or townhouses or this weird animal called a co-op. Anybody heard of a co-op? We don't see them much in Charlotte area. We see them in New York. In fact, I think there's maybe like one. John Sylvia, you met him on the first day. He actually lived in a co-op like when he first moved to Charlotte, one of the only co-ops. And then also a timeshare. Anybody ever live in a condo? Start with a condominium. Thing about the condo is nice is you can come and go and somebody handles the common area, right? You go to the pool, but you don't have to clean the pool, right? You've got a common area that you share with the other owners. What do you own when it's a condominium? Any idea? Do you own the dirt on which the building stands? You do not. The condominium, it's all about airspace. You own from painted surface to painted surface, painted wall to painted wall. Horizontal ownership, the airspace. All that common area, the lobby, the elevator, the sidewalks, the gym, the pool, you own that alongside your co-owners, the other residents, as tenants in common. Hey, there's a phrase we just learned. So you all co-own the common areas together as tenants in common. You own your individual unit as a fee simple, some version of fee simple. Hopefully fee simple absolute, because that's the best way. That makes sense? So the thing you know about condos, you own the airspace, and you co-own as tenants in common with all the other owners the common areas. And when we get to the chapter on insurance, we'll see that this is important, because the kind of insurance policy you need for a condominium is different than what you need for a townhouse or a single family house, because you don't need to worry about the exterior. The insurance company doesn't need to worry about shelling out money to fix the roof. That's handled a different way, because all you own is the interior stuff. It's a different kind of policy. So those common ownership elements like the boat dock or the gym or maybe even a parking space or like a garage, a single garage, tennis courts, swimming tennis, all that fun stuff. You could have common elements like the swimming pool and the tennis court. You could also have limited common elements, meaning everybody has access to the pool and the tennis courts, but only some even own a boat, and some of the owners inside there pay extra for the boat slip or pay extra for the workout facility. So those would be considered limited common elements versus common elements. When it's a new condominium, this applies. The North Carolina Condo Act of 1986, and it's about time for a break. Let's talk about this and then we'll have a break. The North Carolina Condo Act of 1986 says that when you're buying a new construction condominium, the developer has to do some extra stuff. They've got to record a declaration saying basically, here's the project I'm building. They've got to record a plat. A plat is a map. It just shows the layout. Here's the buildings. Here's where they are in relation to the roads. Here's how many units per building, that kind of thing. The developer must create a unit owners association, basically an HOA or a TOA. Well, maybe it'd be a UOA, according to this phrase, an association, a board who manages things, who makes sure that people put their garbage can back when they're supposed to, or I guess in a condo, you're taking it to a dumpster, but make sure people don't leave trash outside their door. They go ahead and throw it away. The developer must also, when you purchase a new construction condo, you have 7 days to back out. 7-day right of rescission means if you get buyer's remorse the next morning, you've got an entire 7 days to say, you know what, I got a little carried away. I don't want to own this condo. I'm out of here. That's for new construction condos, not resale condos. That's all under this Condo Act of 1986. It applies to new construction condominiums and condos only, not townhouses or what's called planned unit developments, PUDs. Not for townhouses, it's for condos. You have a 7-day right of rescission. That's a big key point. Privilege of a new construction condominium for a buyer. The right to back out. Rescind. 7-day right of rescission. That's a condo. Now, what if it's a townhouse? Anybody ever live in a townhouse? I'm looking at faces. The big difference between condos and townhouses is the dirt. With a townhouse, the land it sits on, you also own. You own that too, however small it may be. And I always make the joke, I'll give you a pair of scissors so you can cut your yard, right? Because the little bit of land in the back is so tiny. It's maybe 10 by 12 or 20 or something. Especially if they put a big old privacy fence around it. Sometimes it's better just to put concrete or gravel on the whole thing and not even worry about mowing it or trimming the grass. When you see townhouse ownership, while condos were more of a horizontal thing, wall to wall, townhouses are vertical. They are each floor, including the ground, the exterior included. So you own your unit. The common area in a townhouse, though, is different than how it works in a condo. With a townhouse, the homeowners association owns the common area. You get to use it as part of your living in the community, but it's the HOA who officially owns it. Big difference. In a condo, all the owners own the common area as tenants in common. In a townhouse, The HOA owns it. They own the common elements. Are we good? This is all fuel to be this is all great to be a nice chart for you to write from scratch, draw out from scratch. So your homework from today is to make a bunch of charts where you write from your memory what all these things are to help you figure them out. Don't even study it first. Just write what you remember and then go back and check and see where you went wrong and correct it, and it'll stick in your memory better. We've talked about condos. We've talked about townhouses. Let's talk about co-ops. Cooperative ownership, totally different animal. We just don't do that here very much. Bigger cities, you see it. Because with a co-op, what you own is a share of stock in a corporation. The corporation owns the building. You own the stock in the corporation. So instead of getting a deed on the property, what you have is a stock certificate. And the thing that gives you permission to live in that particular unit is a proprietary lease. So this co-op type is a combo. You get a stock certificate and you also have a proprietary lease for your specific unit. It's not very common here. It's about all you need for the co-op. It is unique also in that the board can kind of say who gets to live there. If somebody wants to buy one, you got to pass and get permission of the board. They can say, "Oh no, you can't live here." That gets a little tricky, right? That sounds sketchy to me. But there is definitely a little more of that element involved with a co-op. Then we have this thing called a timeshare. Anybody ever sat through a timeshare sales pitch? Hands up in the window, please. Was it in North Carolina? Anybody did one in North Carolina? I have a feeling the ones in North Carolina are not as annoying because in North Carolina, at least, the timeshare developer has to have a real estate license. They are governed by the Real Estate Commission. I don't think it's probably the way in Nevada, South Carolina, Florida, maybe. And maybe that's why they get so almost abusive and just so miserable. I don't know. Just a guess. Timeshares. What you need to know for the test on timeshares is this. It's the right to occupy real property. You don't own it. What you own is the time, your time in it. And think of it this way, 5, 5, 5, 10, 5. Write that down, 5, 5, 5, 10, 5. You have the right to occupy this property, this timeshare, 5 times over 5 consecutive years or periods. If you buy a timeshare, you have 5 days to regret it and back out. But I think they know how to win you over and keep you excited for longer than 5 days before you realize that you should have backed out. I hear more often people say, "Do you know how I could sell my timeshare interest?" So 5, 5, 5, 10, 5. 5 times over 5 years, you have 5 days to back out. The developer must hold the earnest money deposit for 10 days so that they can give it back to you if you do back out, right? That's the 10. 10 days required by the developer to hold your deposit, your earnest money deposit. And then the last 5 has to do with the Real Estate Commission. Because if that timeshare developer violates something laid out in what's called the Timeshare Act, which is basically how they're supposed to behave and handle this business, this timeshare development, they can be fined $500 for every violation of the Timeshare Act. Timeshare Act just kind of spells out, here's how you're supposed to do this. And so if they screw that up, they can be fined by their commission. That's the only case where the Real Estate Commission can fine a licensee, is if that licensee is a timeshare developer. That's probably important to note. Timeshare salespeople must have a real estate license. They have to be governed by the commission. And the industry of timeshares, the developer is regulated by the commission, NCREC, North Carolina Real Estate Commission. That developer has to get a certificate of registration through the Real Estate Commission. So I think that keeps them hopefully behaving a little better. So the owner has the title to the unit. and owns the common area with the other owners. Which of the last four things we talked about is this? Owner has title to the unit, owns the common area with the other owners. Common area with the other owners as tenants in common. There we go. Condo. That's condo. Tenants in common with the other owners. Condo. What about this one? Owner has title to the unit, owns the land and the building. Not just the building, but the land their unit is on also. That's townhouse. Townhouse is about the land. Owner has a share of stock in a corporation and then a proprietary lease for their individual unit. There you go. Perfect. Co-op. Short-term memory is working strong. Good job. The owner has ownership or leasehold for a certain period of time. It's not like a deed. It's about time, and that's a timeshare. We come back from break. We'll talk about trusts. Let's come back at 12:11. Let's come back in 10 minutes. Welcome back. Gonna ride out this last hour today. Hopefully it's been going pretty short, pretty quick. All right. Continuing on. This is not a question that is written out here. Let me just ask you the question before we go over into trusts. Which type of ownership, tenants in common, joint tenancy, or tenants by the entirety, which type should a person utilize? What type should they utilize? In the chat. Which type should they utilize? Should they be a tenant in common, or a joint tenant, or a tenant by the entirety? It's my favorite answer in the real estate business. It's that guy. Whichever they want. It depends. What do they want to accomplish, right? Do they have kids? Do they have heirs? Do they have a spouse they co-own with their 3 college buddies, and they have a spouse, though, so they were thinking about buying it with the buddies as an investment. And the buddies want to do it as joint tenants because they're all single, but you have spouse and kids. You might want to do tenants in common so you can leave your part to your kids, your spouse. Here's another fun real-world thing that can happen. Boyfriend, girlfriend, out of college, buy it as tenants in common. You know, remember, he's pretty. He's pretty. She likes him, but he's not very responsible. He goes mountain biking and falls off the side of the mountain and dies. Oh, so sad. Who does she own this condo, this townhouse with now? They're tenants in common. He doesn't have a will. Of course he doesn't have a will. Why would he think to have a will? And if you don't have a will, it goes to your heirs. Who's the heirs of some single person? First line of defense besides your kids. If there's no kids, it's your parents. Oh, by the way, his parents hate her. Now she's the co-owner with his parents. That's why it's important to nail this stuff down the way you want it to be nailed down, right? Yeah, so tenants in common has no right of survivorship. Therefore, it can go to the heirs. In his case, he has no kids, so his next in line heirs are parents. And I think after that, in the lineup legally, it's kids, parents, siblings, and then maybe like aunts, uncles, and it just goes on down from there. State's first going to say, did he have a will? Second, it's going to say, does he have heirs? Who is it? What's the relationship? So yeah, it could get messy. Trusts. You don't have to know too much about trusts. You need to know who the parties are. There's a beneficiary, the one that's being given some stuff. The trust is the vehicle that this stuff is being given to the beneficiary. The trustee is the one who's in charge of the trust, not the beneficiary. It might be a case where it's maybe a wealthy thing where the parent wants to give the kid $1 million, but the kid is only 17, and the parent says, yeah, I'm going to give you $1 million in the trust, but you don't have access to it until you're 30. And in the meantime, the trustee that I put in charge of it is the one that's going to decide how it gets spent. It's for your college. It's for smart decisions. You're not smart enough to make those decisions if I die. So therefore, a trustee is going to make these decisions based on a set of rules that I give them. It's for education only, or this or that or the other. Maybe a decent car, not the Maserati. Scale it back. It's for a reasonable car, right? You just lay it out. That person who sets up the trust decides the rules of it, and it's the trustee, probably an attorney, who carries it out. And it's the beneficiary who's getting the stuff that was put in the trust. It could be real estate put in that trust. The assets. A living trust is something done during one's life. Let's take a look at your textbook, page 41. We're on page 41. Hopefully you can see that okay. It's a little dim. Let's see if I can brighten this up a little bit. Nope. I think you can maybe see it. So assets are being held by a third party, the trustee, probably an attorney, for the benefit of the trustor is the one who sets it up. It's their assets. They're giving it to the beneficiary. So the trustor owns the stuff that they want to give to the beneficiary, and they have the trustee in charge of it because they're probably setting it up for if they die. It's a fiduciary relationship. We'll get into fiduciary when we go to agency in chapter 7 and 8. That is a very high level of trust and responsibility. If you have fiduciary responsibility for someone, you're held to a high standard because you're taking care of very important things in their life, specifically and most importantly, money. And it often involves real property. So the thing about the trust, why do people use trusts? Notice rich folks use trusts, probably because some smart advisor told them they should. Regular and poor folks don't know much about it. It's not that it's super expensive to use a trust. It's just that people who are educated differently in their different stratospheres of wealth. And the ones that are rich have good advice givers. And so they know about these little things. So one cool thing about a trust is it allows things to pass outside of probate. Oh no, not another legal term. Probate just means the process of handling your assets when you die. When someone dies, you've got to open up their probate at the courthouse and say, hey, this person died. Now we've got to figure out, did they owe anybody stuff? We're going to take the value of their assets and pay the creditors, whoever can come forward and say, yeah, she owed me money. If they can prove it, then part of that deceased person's assets will be used to settle up. That's part of the probate process. And if you're lucky enough to be the executor of her estate, it's your job to open the probate at the courthouse and see that all these things are tended to. Not fun. It's an honor, but it's not a privilege. If anybody's had to be an executor. My favorite term in this whole concept is a female executor, which is called an executrix. T-R-I-X, executrix. That's just a fun word. Courts want to verify that the will is valid and make sure that any debts are paid. Let me flip the page and let's refocus a little bit. If it's a living trust, it's also called a revocable trust, created during somebody's lifetime. It's to place assets in there for somebody's benefit while they're still alive. And then it's going to be transferred when the beneficiary, to the beneficiary when the trustor dies. A testamentary trust, you can see right here, involves leaving assets to kids or other cases where it needs to happen at a certain time, maybe like that 30th birthday idea. And I wrote will and testament as a reminder. Testamentary, just think of last will and testament. It's that kind of a thing. Or maybe upon graduation of college. And then the next thing, land trust. That's when you use a trust so that you don't have to admit that it's you who owns it. It can be, because right now you could poke into your neighbor's business and they into yours. You could go to your local GIS of the city, county your property is in and see who owns the house next door, unless they own it as a trust, in a trust. And let's say Michael Jordan owns the house next door to you. He's not going to be listed in the tax records as Michael Jordan, the owner, the celebrity basketball star Michael Jordan, that guy. He's going to probably own it as 123 ABC Street LLC. That's what they do. That's what celebrities, that's what rich folks do. With land trusts, they own it in trusts so that they don't have to admit how much they own, because who knows how much stuff he or anybody else who has a bunch of money owns. He probably owns a whole bunch of property all around. And if you're rich, you already have a target on you. People just looking for reasons to sue you, right? So it's privacy. Land trust is about privacy. And it's also to avoid that process of probate. I think I got away from that topic. When you're deceased, you have to your executor, executrix has to take your belongings and go through the probate process. But when you leave real estate to somebody in a trust, you don't have to go through that probate process. So it helps avoid the probate process. Notice down here toward the very bottom, like right here, it says a person wants to sell a parcel of real property she inherited supposedly and is willing to sign the listing agreement. She's excited to sell it. You're excited to get the listing, but you ask more questions and you realize, oh, wait a minute, you're the beneficiary and it's not yet time. You don't actually have the right and the authority to make this decision because you're not 30 yet or whatever the condition is. Therefore, I'm talking to somebody that's irrelevant. You might want to sell it, but it's not yours to sell for 3 more years. If you want to sell it, we got to make sure the trustee allows you to sell it. And I need to be talking to the trustee, not you. I need to get their signature because that's who's in charge of this right now. So as a broker, determine who actually has the right to sell the thing. Can she sell it herself, or do we need to get the trustee involved and consult that trustee? In real life, in the wild, if these words come up, what do you think you do? You step away. You pass it off to the attorney. Don't give them illegal advice. We're going to tell you that a million times. The words for this thing called trust, the trustor is the one who created it. It's the one who's given stuff away, money, real estate. The grantor or the trustor, that's the one who's putting the stuff in the trust. The one that they want to give it to eventually is the beneficiary, and the person running the show until the beneficiary meets the deadline or the time period or the whatever, college degree, the one who's in charge is the trustee, has that fiduciary control over the property. All of it is set up under the instructions and of the trustor. We're going to see other words that end in OR and EE. And it's usually the giver is the OR word. The receiver is the EE word. I just think receiver, right? And it's oftentimes it's just the 2 pieces to the puzzle. With trusts, it's a 3-piece thing. With mortgage deed of trusts, we'll talk about that later. There's another 3-party thing. But for the most part, it's a giver and a receiver. The one giving the lease is the leaseor. The one receiving the lease is the leasee. The one making the offer is the offeror. The one receiving the offer is the offeree. Probate is the legal process of distributing the assets of a deceased person. We'll see later what happens when somebody has no will. No will. That's part of the executor's job, by the way. Hey, is there a will? Let's take a look at what their wishes are within the will. We still have to open up the probate and make sure that all their affairs are in order. One of those processes, you won't be tested on this. You have to run a classified ad in the newspaper, whatever that is, for like, I think 30, maybe 60 days and just tell the world, look, he's dead. Did he owe you money? Now's your chance to come forward so that we can settle up their affairs before we close the probate. Then it's too late. I was the executor of my mom's estate, so I had to go through this whole process and go down there and say, list out all of her stuff and here's what we got, and run the ad and see if anybody came forward. Nobody did, thank goodness. And then disperse with my brother the remaining belongings and value. Insurance policies, getting death certificates, passing them off, making sure everybody has proof that the person died. So all of that falls under this concept of probate. Oh, and so if you die without a will and you die with no heirs, no will, no heirs, sad, and you have real estate, the state, through the process of escheat, we'll see later, ESCHEAT, escheat, can take it. The state gets it because you had no will or heirs. So get wills made. Everybody, lesson to take besides how to pass this test is get a will. Okay, let's see. Couple of vocabulary items. We already learned this word, appurtenant. Something appurtenant is a benefit. It runs with the land. Appurtenant is a benefit. In green, the opposite of that is an encumbrance. An encumbrance is a burden. An encumbrance is a burden. We're going to see about how you can encumber a property. You could encumber a property by putting a mortgage on it. Now it has the burden of getting that mortgage paid off. You couldn't even buy it without the mortgage. So in order to get it, you had to put the mortgage on it. You had to borrow against it. That lender, happy to borrow against the property because part of that deal is if you don't make your payments, they get to keep the property. They take it over and they get it. That is an encumbrance, a burden on the property that you willingly went in with because it's the only way you're able to buy it for 90% of people out there. So an encumbrance that's, I would say, a positive thing because it lets you it gave you the way to buy the thing. But there's also negative encumbrances. Either way, it's a claim attaching to the property. It affects the title to the real estate. An encumbrance, there's lots of different kinds of encumbrances. That's what we're getting into here. An encumbrance can be a right that you're giving to an entire third party unrelated to you, not an owner, like that mortgage company. You're giving them the right to take your property in the act of foreclosure if you don't agree to your end of the deal, which is to pay the mortgage as you promised. So it's a right held by a party who is not the owner. It could affect the value of the property. If you have a bunch of liens against your property because you didn't pay your taxes and you didn't pay the guy who put the roof on your house and he registered and recorded a mechanic's lien against your house, you have a whole bunch of liens against the house, and you don't have the money to pay off those liens, and you just want to sell the whole property to a buyer subject to the existing liens. Say, I'll sell it to you, but you're going to have to handle the liens yourself because I don't have the money for it. Is that buyer going to want to pay you top dollar for that property if what they're buying is the house plus all of your debt? They might be willing to buy it, but they're going to want a steep discount, right? They might buy it for 50 cents on the dollar, but as long as they can pay all those liens off and still end up with something worth a number that works for them. So it affects the value, could affect the use of the property. It does not keep you from selling it. You could still sell the property. You can still transfer it. That's all that means with transfer, just selling it. So a type of encumbrance is a lien. A lien is a type of an encumbrance. It's a burden on the property. But not all encumbrances are liens. There are more encumbrances that are, lien is just one of them. We'll get into other types of encumbrances in a moment. But encumbrance is the top line word, and below that is a lien, as well as other examples of what are encumbrances. So there's our encumbrance. There's our lien, which is one of the many types. And a lien is just collateral against your unpaid debt. And they attach it to your property so that when you sell your property, you can't just take the entire chunk of money that you got for it from the buyer. If you have liens registered against your property, you're not going to get the entire $200,000. You're going to get the $200,000 minus the $30,000 you owe in back taxes, minus the $150,000 you owe to your lender for their lien. And what you're walking away with is, what is that? 200 minus 180, $20,000. Not as fun as getting 200 because you had to pay your liens off. But those are encumbrances. Another thing that's a burden on the property is an easement. Giving someone else, third party, permission to go across your property. It could be the utility company to get to that green box at the corner in the back so they can open it up and handle the power, handle the phone lines, handle the gas, whatever it might be. Utility companies have easements across private owners' property sometimes. They have the right to access because they need to get there to handle the lines, the power, the water, the sewer, the gas. Those are easements. It could also be a driveway easement because your property could look like this. cables are getting twisted up here. Here's our road. The road right out front. Here's your neighbor's property. He's called A. Here's your property. You're called B. You are what is called landlocked, because somebody else owns this chunk and somebody else owns this chunk and somebody owns this chunk. You can't get to the road without crossing over somebody's property. You got to cross over your neighbor's property. And so you have a driveway easement across your neighbor's property. It benefits you because it gives you the way to get to the road. It's a burden on them. So it's an encumbrance to them. This easement is an encumbrance to owner A, because now they can't use this piece because you're using it for your driveway and they can't get rid of it. They can't not let you have that. And when A sells it to someone else, the new owner, C, has to honor that too. They are buying this subject to having this encumbrance, which is an easement, a driveway easement for you. And we'll learn about that in just a moment. But it is this chapter, so I'll go ahead and tell you. The name of this property is the dominant estate. Dominant because it is B who has the right to use this thing. This one is called the servient. This one, servient estate, because it is them across whom that easement runs, and they have to honor and allow that. So that's easement. It's an access or a right. Also an encroachment. Could look like this. We've got these folks. What if B, and let's say this guy over here is E, what if B builds a 3-car garage and oops, he went over the line by that much? He is encroaching on E's property. So now there's an encumbrance on both properties. There's an encroachment. It extends over the property line. It's going to be tough for B to sell without handling this legal issue. Can he move this garage? Probably not that easy without destroying the whole thing. Can maybe E give him permission to leave that corner hanging over there? Maybe. But E needs to think, now E's going to have to inform any future buyers, look, I got this thing, my neighbor's corner of his property is over the line. We have an agreement that I'm going to let him do that, and you can continue to let him if that's what he agrees to. But E might say, no, I'm not signing anything. You were the one who screwed up. You should have had a survey done so you'd know where your line was. I don't want you on my property. Get it off. But I'll have to tear down the garage. Tough in the world of grumpy people. So liens, easements, encroachments, some other encumbrances include deed restrictions. Here we go. Deed restrictions. You bought the property subject to whatever restrictions are in that deed. What would be an example of a deed restriction that, I don't know, we talked about 2 hours ago? Deed restrictions. Fee simple. There it is. You bought it subject. You didn't buy a fee simple absolute deed. You bought a fee simple defeasible determinable, or subject to a condition. I come back around full circle, right? And then you just feel that sense of resolution. So like listen to a song, come back around to the chorus. That's what we're talking about. Deed restrictions. You bought it under certain conditions. Also restrictive covenants. That's what you have to do because you're living in the HOA neighborhood. You can't put a 10-foot privacy fence. The restrictive covenants won't allow. You can't paint the door purple. You got to leave it boring beige. We're going to talk about more of that in Unit 6. There's also some legal examples of encumbrances: a writ of attachment, lawsuits, a lis pendens. We'll look at in a minute. Liens. We're talking about liens. We're talking about this one, this version, this very first type of an encumbrance. You owe somebody money, therefore they put a lien on your property so that if you ever sell it, they're going to get paid. They're first in line maybe, to get paid from the proceeds of your sale. You can't sell without them getting finally what you owe them. And a lien is just providing some sort of security. That's why the mortgage is probably the best possible interest rate you could ever have when you owe money to somebody. Certainly a mortgage rate is better than a credit card rate or an auto rate, because that mortgage lender feels pretty confident that your house and your land is not going to disappear in the middle of the night and be driven away to Mexico or get destroyed. Yeah, the house could be destroyed, but there's insurance that covers that. The land, pretty tough to destroy land. So mortgage lenders are pretty confident and happy to loan you money. Because worst case scenario, you stop your end of the deal, you stop paying that mortgage, they're getting your property back. You told them they could have it because you were so confident that you're going to pay that mortgage payment. Security for debt. That mortgage company can't come in and live with you. They can't come in and sit on the couch and eat Doritos and watch the game with you. That's not part of the deal. They're giving you the money, but they can foreclose on you if you stop paying. That's what's called a voluntary lien, where you agreed to it. Because why would you agree to putting a lien on your house? So that you could own the house, right? You didn't have. Do you have $300,000 laying around to pay cash with? Probably not. I would dare say, I might be wrong, I'll bet the majority of us in this room don't have it laying around. Or even if you do you want to use it when the rates are only 6%? Yeah, I said only 6%. I know they were only 2.75 2 years ago and only 3.5 last year, but that doesn't mean that 6 is bad. It's all relative, isn't it? 1980s, it was 18. Margie probably remembers a higher interest rate, the double digits. What's the worst one you remember being in the business, Margie?
21%.
Ooh, wow. 20.
2 doctors, and they qualified at 21%. And then the minute the rates came down, of course, they refinanced.
Good gosh. What is it?
I couldn't believe it.
That's a credit card rate. That's a bad.
Right.
That's a bad credit card rate.
I'll never forget that, Neal, ever.
Bad. The mortgage guy will tell you you should. What is it? You should marry the house but date the rate. That's what they say. Because go ahead and buy the house at the terrible rate, and then when the rates subside, you have the house and then refinance. Just refinance your way down in lower and lower rates, right? But you have the benefit of the house. That's what we're going to say now, because values are still high. We got to talk these people into buying stuff somehow. I'm kidding. It is usually in their best interest to buy a thing. So that's the one thing to consider. Hey guys, I know if you're going to run away from buying anything because the deals aren't as good as they were 10 years ago, you're never going to buy anything. It's the new reality. Here's just the way it is. Take it or leave it. If you buy it or not. But are you really going to wait to get that $300,000 house for $60,000? I don't think any of us will be alive when that happens. I think the world will probably be ruled by martial law, and the zombies will be in charge at that point.
Neal, during that time, the latter half of the 70s, late 70s, we truly, none of us in the business thought we would never see a single digit interest rate again. We really, really believed that. So you never know.
You really don't. That's true. Good point. Time is funny. Well, you put this lien against your property voluntarily because that's the only way you had to buy it. So that's what it is. A voluntary lien example is a mortgage. You're agreeing to the lien voluntarily. The involuntary lien, a good example, is a tax lien, because you didn't want the state or the city or the county to put a lien against your property because you didn't pay your taxes, but they did. They had the authority to do so, or a foreclosure, same idea. So voluntary is positive, involuntary you can think negative. It could also be a result of a lawsuit, a judgment a judge places upon your property that comes up because you're in trouble legally. That could be one of the ways they handle the outcome of that legal issue. Now, this might be a point of confusion from your reading. Specific liens versus general liens. When we're determining, just think a bad case scenario. Somebody's getting in trouble financially. They have medical bills. They have all the bills. They have all the late bills. Well, they didn't pay their mortgage for the last 2 months. They didn't pay their tax bill when it was due last year. They had work done on the property because it's always the property's in disrepair. So they had the roof done. They had a heating and air system done. They didn't pay either one of those professionals. So they have what's called mechanics liens against the property. They have a bunch of liens against their property. They also didn't pay their state income tax or the IRS federal income tax. And those entities have put liens on the property. All of those liens are not the same. They're not just getting paid at the same time. Money, there's only so much money. If this property is sold or if it's foreclosed, there's only a finite amount of money to work with. So which of all of these liens gets paid first, if at all? That's what we're talking about here. Specific liens get paid first because they are specific to the property itself. What is a specific lien? What lien is specific to the property? The mortgage, because you're using that mortgage to buy that specific property. The property tax, because it is a tax on that specific property. What about your income tax from the IRS, your federal income tax? That's not specific to your property. That's the same thing whether you live in that house or the one next door or the one across the street or if you rent. Has nothing to do with the property. Therefore, it is a general lien. If you get in trouble with the IRS, whether state or federal, those are general liens. They're not specific to the real estate. That makes sense? And in the case where you have limited funds with which to pay these various liens, the specific ones get paid first. Oh, wait a minute. I thought the IRS always wins. I thought the federal government always wins. Nope. Specific liens get paid first. Now, specific liens are about the specific property. General liens can encumber both your real and your personal property. A superior lien, I don't really like the way this is written because it's not like there are 3 categories here. Superior lien is just another term, but it's like specific or general. Is it in the specific lien bucket or the general lien bucket? A superior lien is a lien that needs to be paid first. It is first to be paid. So a specific category lien is superior to a general category lien. In other words, your property tax is going to get paid before your mortgage lien. Your property tax lien is going to get paid. Well, that is true, but but they are both kinds of specific liens. Here's the other thing. Oh, that might help. Specific liens are about the specific property. General are about both real and personal property. And superior is just the first to be paid. A non-possessory charge against property that provides security for a debt or an obligation of the property owner. That's the definition you saw in your book of what a lien is. All of that just means a collateral. Now let's dive into specific liens. It's about the property. It includes your ad valorem, at value, your real property tax. Later, for you math fans, we're going to learn how to calculate your real property tax. Special assessment lien, that is specific to your property. It's because you and all your neighbors up the street are getting a street light and a sidewalk. Congratulations, but that also protects and helps the public good, but it's also benefiting you. Therefore, the city is now going to charge all of you who are getting lights out in front $500 a month for the next 10 months. That's not fair. I didn't ask for this light. Sorry. You're getting a special assessment. Oh, you want to sell your property because of the special assessment or any other reason? You got to tell the new buyer, hey, there's an assessment. It's an approved, confirmed assessment. But I still owe. I decided to do the payment plan. I still owe 3 more months on it. You're not going to have to pay that, Mr. New Buyer, because it was confirmed before I sold it to you. Therefore, I get to pay the balance. That's the thing about, we'll learn about that in contracts. Real property tax, special assessment liens. Oh, you didn't pay your special assessment. Now it's a lien against the property. It's a specific lien. The mortgage, mechanics liens because you had a roof put on it. That's specific to the property. Commercial broker lien. Oh, This is a weird thing. Oh, we'll get to it in its own slide, but it's just around the corner here. Let's look at it. A commercial real estate broker lien. Guess what? It is not applicable to residential real estate brokers. I know that's hard to believe because, because of the title and stuff. This applies to commercial real estate. If you're a commercial real estate broker and you list a property and you get an idea maybe that the owner is kind of coming up on hard times and you've done work, you've listed it, you are the listing agent, you have a listing agreement. They agreed to pay you money. And you realize that they're starting to put liens against this property that I've been hired to list. I'm going to add to that party. I'm going to put a lien on the property for the money they owe me. It only applies if it's a broker that has a written agency agreement. You have to have proof in writing that you are their agent. It only applies to commercial transactions, not residential. And it allows that broker to put a lien on the property so that once it does sell, that broker's commission gets covered. They're going to get paid their commission. I wish it was in residential. I've had a deal or two where the seller, in one case, declared bankruptcy. In the 5 months I had that thing listed and brought them a buyer contract, they decided to declare bankruptcy and they got to walk away from all of it, including all of my 5 months of time. And I did everything I was supposed to do. I brought them a ready, willing, and able buyer, but I was out. Yeah, I probably could have pursued them, but do I want to do that or not? That's a business decision. But I could have, and if it were a commercial transaction, a commercial real estate deal, I could have put a lien against that property to protect my commission. Now, in a case of a bankruptcy, I doubt that would have mattered either. But point is, commercial real estate broker lien allows the real estate broker to put a lien against the property, but only if they have a written agency agreement, and it's only in commercial, and it protects their commission. We get more into these in your post-licensing classes. So that's what a commercial broker lien is, to go back to this one. Now, look under this one. Mechanics lien, contractors, that's a type of specific lien. It's specific to the property. So that roofer, that plumber, that electrician can, if you don't pay them, they can file a lien against your property. So when you do sell it, they're finally going to get their money, hopefully, unless all of the stuff ahead of them doesn't leave any money left for them to get a piece. But let's look at what a mechanics lien is. A mechanics lien is for such vendors as that. HVAC, heating and air repair people, roofers, plumbers, electricians, any of those who do work for your property or provide materials to your property. If they get the idea that you might not be planning to pay them, they could file a mechanics lien. They would need to have a contract, a written contract with the owner of the property. They must file their lien within 120 days. You need to know this stuff, and it gets a little weird and confusing, but hang in there. So when would they go to the courthouse to file the lien? When you file a lien at the courthouse, you're basically telling the whole world, look, they owe me money. You're filing it with the courthouse. You're recording it. They're filing it with the courthouse. They're filing that lien. They have a time limit. They only have 120 days, 4 months after doing something, after either doing labor or providing you materials. Then there's a 4-month, 120-day clock ticking, during which if they figure, oh, gosh, I get the feeling this person is not doing well financially. They haven't paid me yet. I was supposed to get paid even just for my materials. They've been dodging my phone calls. I'm just getting a bad feeling. Therefore, let me hurry up and file this lien with the courthouse within 120 days so that I get in line. Because the first one to go to the courthouse and file the lien is the one that gets paid first. Because if they're not paying you for the roof, they're probably not paying him for the plumbing. That's how that works, the snowball effect, right? The first mechanics lien to get filed is the one that gets paid first, in order of recordation. That's the phrase, in order of recordation, order of it being recorded. In North Carolina, it's what's called a pure race state, like race to the finish line. Whoever gets to the courthouse and records their lien first is the one who gets paid first when the money is available to be paid. So you want to be filing as soon as you get a feeling that it's going bad. So you got to file that lien within 120 days after either providing the labor or the materials. And then there's another timeline here. They must enforce the lien within 180 days after providing labor. What is the difference? Filing is putting it as public record in the courthouse that they owe you. Enforcing is saying, now I want my money. Pay me my money now. So 181 days is too late. You're outside of the limit. Within 180 days of having done the work and provided the materials, when you have to enforce, hey, give me the money now. The lien takes effect from the date the person first furnished either labor or materials. So you have 120 days to file it. You have 180 days to flex and enforce it. But what if it's you and the plumber? You're the roofer. The plumber also wants theirs. Which one of you first furnished labor or materials? That's who's getting paid first. That's what it means by lien takes effect from date first furnished. See that? Let's look at this example. First day, labor and materials are provided is February 1st. The last day labor and materials were provided was June 1st. It's when you packed up and you drove off. You file the lien on September 30th. You file the lien with the courthouse on September 30th. I mean, okay, that's what it is. The last day you could file the lien is September 30th because that's the 120 days that you're allowed to file the lien. And then the last day that you could enforce the lien will be November 30th. There it is. And then you're in line for collection because you first provided material on February 1st. What if the plumber first provided material on January 30th? As long as they filed the lien and tried to enforce it, they're ahead of you. They're getting paid first. I hope their plumbing work does not exceed the amount of money available so that you can get some money. Because usually it's a whole bunch of liens and it's just a matter of who's getting done out of some money. That's specific liens. Let's look at general liens. That's below, subservient to specific liens. Specific is about the property, the specific property. General liens can encumber all of your property, both real property and personal. It's things that don't just apply to the specific real estate itself. It could be a judgment. You get in some sort of legal trouble, maybe for a car wreck, who knows, something where the judge says, you're going to have to pay some money. I'm putting a judgment against you. Oh, you don't have money now? We'll put a lien on your property or against you, the person. And even if you sell a real estate property, you're carrying this judgment around on your legal shoulders until you pay it. Good luck getting a loan because you have a judgment on your actual personal property, your own self. Just because you sold the real estate doesn't mean the lien is gone because it's a general lien. Personal property, that's the car tax situation. State tax, the North Carolina Department of Revenue puts a lien against you. Well, that applies to you, the person, not just your real estate. And then federal tax as well. So if you owe your mortgage if you have a lien against your property for your mortgage, but you also have an IRS lien, which one gets paid first, according to this? The one that's specific to your property. That's the mortgage. The IRS is a general lien, not a specific lien. The effect of liens could cause the value of the property to come down because you got a bunch of liens on it. You can't pay them. You want to sell the property. That new buyer will buy it from you and pay the liens for you as long as they can get a great deal. They're going to want to pay a lot less. And you can sell it to them. It's not unsellable as long as you tell them. You can convey title, sell to someone as long as you tell them, look, there's liens. And they buy it subject to those unpaid liens because they're going to clear them up so that the liens don't stay on the house. And sometimes certain liens can end up causing a foreclosure. So that new buyer certainly doesn't want that to happen. They're going to have a plan for paying off those liens. And part of that plan is, I'm not paying you $500,000 for this because that's what it's worth. I'm going to pay you $200,000 for this, and then I'll clear up those $60,000 worth of liens that you've accumulated. And now I'm still better off. So, does an encumbrance or a lien prevent the transfer of property? You can still sell it. You can still sell the property even if it has liens on it. Does not prevent the transfer. And to get a little nuanced with that driveway thing, a grantee who you're giving it to or selling the property to, they can't refuse an easement as an encumbrance. Just because it has an easement as an encumbrance, the grantee can't say, well, I don't want to buy it because it's got that. They can choose not to buy it for other reasons, but not because of that. The grantee could agree to assume responsibility for a lien, but they're probably going to want to pay less for the property because they're going to have to pay for the lien. Okay, we're going to talk about this when we come back. I want you to read the stuff about liens, get that under your belt, because then we're going to talk about what order things happen in, and then I'm going to show you this exercise, which is what order to put these liens in. It's going to require some thought. And you're going to have to think, okay, when was it put in place? When was it recorded according to the dates? And also, is it a specific lien or a general lien? So I'm going to respect the 4 hours time you've been putting in, and tell me, though, some of your questions. Give me any sort of concerns from today, questions, anything that you're still confused about or that in your reading you're seeing coming and you're like, I don't want to deal with that. Tell me something. Got anything? We're still in order. We're going to be in order the whole time. After we get through with 2 on Wednesday, we're going to go straight on into 3, 4, and 5. Not all on Wednesday, but they're in order, so keep going. Oh, good job, Twee in the chat. Anybody else want to make a guess as to what order these liens should go? Twee says property tax lien comes first. And that is true, because what we'll also learn more on Wednesday is there are 2 categories that are always first and second. No matter what, you always have to pay your property tax first. They're always in the first position. Second is special assessments. Notice that both of those are liens from the government. And remember, the government is who wrote these laws. So they put themselves first and second. Imagine that. Yeah, that's a good idea. Thank you, Doug. Put any other questions you get along the way, anytime, put it in Notion. Just go there, open it up, and you have a comments block, and you can write your questions in there. And that way we'll see them. We'll be notified of them. I saw a comment just the other day. I think it might have been Jennifer, and that was useful. So use that thing. And if you haven't signed up for it, I think you all have, but just in case, do it, because that's where we're putting a lot of resources. And I move things around in there. So, I don't want you seeing the same old stuff. So I'll bump that to the bottom and put the most recent announcements and things in at the top, so you don't have to scroll down to find things so much. Besides that, it's 1 o'clock, guys. If you have questions, feel free to stay, but otherwise I'll see you on Wednesday.
Goodbye, everybody. Happy studying.
Thanks, Margie.
You're welcome.
Okay, folks, I just ended the Zoom meeting, but just want to do a little quick recap in this recording. This was the entire day 3, and let's see. Yeah, we got into liens. We almost got through chapter 2. We will finish that on Wednesday. Move straight on into chapter 3. They don't all take the same amount of time, so some chapters will fly by. 2 is pretty intensive. It's got a lot going on. So that one is naturally going to take a little longer. But let's see. 3 is about taxation. That's got the first little bit of math in it. So for chapter 3, go ahead and dig into chapter 3 and try to do some of that math. It's probably, I think, let's see here. At the back, yeah, it's a short chapter, but we get into calculating property tax using the tax rate, something called the mill rate or the dollars per hundred. Sounds worse than it is. It's really not that bad. So we're going to do that together. Go ahead and jump on that, get familiar with it. Try to knock out 3 and 4 in your reading time between now and Wednesday, if at all possible. 4 is another one with a lot of terms in it, like special warranty deed and general warranty deed and quit claim. So you might have some questions about that. And then 5 is about land use controls, like zoning. Public land use control has to do with what the city or county allows you to do. The idea here is they don't want the houses, like a neighborhood, to have to be near the dump, the garbage dump, or the asphalt plant. They want to keep all the asphalt plant, dump kinds of industrial stuff over in this corner of the county, and then put the residential over in this section, and then also have like some commercial next to the residential so that you have stores to go to. So they carve that out. If anybody has ever remembered the game called Sim City from years ago, you actually did that. You would carve out your own little residential section and your commercial section, and you would make a town. Then you would set them loose and see how it grew and collect the taxes. It sounds boring, but it was actually kind of interesting. But that zoning is a big thing. So just keep on working your way through. Try to be a step ahead. I'm going to share in Notion this study guide that I mentioned to you. Let me see if I can pull that up real quick. It's going to be prettier than what this is. It won't be blurry. I'll also finish up this little graphic talking about the estates, because I think it's kind of helpful to click on these things and remember them that way. Here we go. Yeah, I'm going to finish up, clean up this study guide, probably add the number of questions that come from the various chapters. That was a suggestion by Margie. Good idea. So I'm going to round that off and save it and send it to you. And then you can see what dates we're kind of be shooting for to get into these various topics. Let me know, as usual, any sort of questions along the way. Feel free to keep them private. You don't have to ask in front of people, even in class. You can just direct message me and I will not call you out. I won't say, oh, so-and-so asked this question. I'll just say, here's a question, here's the answer. So I hope you have a great couple of days. Put some effort into this thing. Make sure you prioritize this. This might mean that you have to get up earlier than normal. Might mean that you go for a store run by yourself and you don't come home as soon as you're done. You go park somewhere and you study in peace and private. It might be that your car is the only place you can have that privacy. So look for these opportunities of where you can get time, and think about the Pomodoro technique. Study hard for 25 minutes, and even if you still have another hour available, take a break. Let it sink in. It also helps to take those breaks so that you can think, that I remember. I studied about liens, and then I took a break and I studied about taxes. So it kind of helps you maybe put bookmarks in your memory about learning different things too. So it's beneficial. There are Pomodoro timer apps you can get on your phone. There's also hard like actual objects you can get, or a kitchen timer, but maybe even track it. Just put a timer on for 25 minutes and your phone will alert you. And when that goes off, just stop, get up, walk around, do a jumping jack or two, get some blood flowing and come back. Maybe go to a different place to study the next topic. Maybe don't always study in the same location. It'll all run together. If you have the luxury of a couple of different locations, especially if you're home alone for any amount of time, maybe you have that privilege that everybody leaves you alone for a couple hours a day. Maybe study in the kitchen for some things and then go study in the living room for other things. It's, all of those little things sound silly, but they really do help to kind of help keep your brain engaged. You want to make lists, make diagrams. We did a lot of that today. Try to recreate the freehold estate diagram and write the bullet points for fee simple absolute, fee simple defeasible, for the life of another, pour out V. All of those are inheritable, and then write the ones for the non-inheritable, marital rights, and also conventional life. Write all of those, as well as like tenants in common, joint tenancy, and tenants by the entirety. Try to make a chart for that. And then randomly, in a couple of weeks, when we're studying something completely different, maybe say, oh, let me see if I can write that freehold estate chart from memory now. Don't look at it first. Try to write it from scratch first, and then see if you got anything wrong. That will help you more than just looking at the answers. Don't lead by looking at the full information. Lead by quizzing yourself. It's all about quizzing yourself along the way. That's going to be your better friend. I hope that helps. Always a pleasure. Appreciate you guys. Let me know if I can do anything to help you, and I'll see you on Wednesday.